All right, good morning. This is Judge Alyssa Perez presiding over the 210th District Court Civil Docket for April 8th, 2026. All matters being heard today are being heard in accordance with all directives regarding remote proceedings. In addition to that, we are streaming all matters live via YouTube for public viewing. I'll go ahead and call it. This is 2025 DCV 2183, Annie Correges versus Christian Anthony Olivo et al. May I have announcements, please?
Your Honor, Jess Mason on behalf of Rico Spirits, the movement, on the original motion to compel that we began last session and continue to today.
Good morning, Your Honor. Pablo Lopez for Annie Courageous, the plaintiff.
Good morning, Your Honor. Nicolas Ocampo on behalf of defendants Tequila General Gorostieta and Don Vicente Tequila.
Good morning, Your Honor. Myra Stanton on behalf of Christian Anthony Olivo.
Good morning, Your Honor. Patterson W. Kime on behalf of the defendant, Mirie Olivo.
Good morning, Your Honor. Alejandra Rodriguez on behalf of E Group LLC.
Your Honor, Mike McLean on behalf of P.L. Howard and Company, and Mr. Howard is with me as well.
Good morning, everyone, again. Yes, we are set for, I guess, somewhat of a continuation. Let me ask first on the motion to compel, and if I'm not mistaken, plaintiff also had a motion to compel that we didn't really get into. Mr. Mason, Mr. Lopez, have you all conferred?
We had,
Yes,
Your Honor.
Your Honor.
We've and we're happy to announce that I think we've resolved some things. We were working towards a Rule 11 agreement, but we didn't. Our emails were kind of flying back and forth. But I think that I can announce on the record, and then Mr. Lopez can confirm as we go through them what we've already agreed to. And I'd say a lot of them have been agreed to, but there's still a few items that we need the court to resolve for us. I did submit with the clerk a comprehensive order that deals with everything, and with there's 4 categories of objections: overruled, sustained, modified, and agreed to for the court's convenience. And hopefully that'll speed things up this morning.
Okay, great. So go ahead and let me know what's left. I mean, however you want to proceed. If you want to summarize what you all have agreed to, I'm going to look up and see if I already received that order, and then I can tell you I'm happy to hear argument on whatever is outstanding, but I will rule on those via submission in light of your arguments today. Okay.
I think the fastest way to do it, Your Honor, is just start at the top of the order and kind of work our way through it, because a lot of it, like I said, has been agreed to.
Okay.
And I sent another copy of that order, if you don't have it, to the clerk this morning, just so it would be at the top of the email.
The email pile?
Yeah, yes.
It's so very helpful.
It went to the MA Nieto at epcountytx.gov.
Okay. I have an order here, a proposed order with the overruled, sustained, agreed.
Okay, that's the one, Your Honor. So I think the first one, Pablo, and obviously correct me if I'm wrong, but I think the first one we agreed, the first one in controversy was request for production number 3, and we agreed to that with the specification that it was limited, just a clarification that it was limited to the date of the accident and prior to the accident. And based upon that understanding, it was agreed plaintiff would withdraw objections.
Yes, that was the agreement.
Okay.
Then with request for production number 7, Your Honor, I think the agreement was to withdraw that, and then he would be producing what he had responsive, which was going to be an exhibit list that he's prepared. Have I got that correct, Pablo?
Yes, that's correct.
So those two, 8, he will withdraw. Yeah, that was agreed to. He'll withdraw the objections and respond. Then 15. I think there was a marshalling there were objections removed, but not the marshalling objection. Correct, Pablo?
There is a marshalling objection and an overbroad objection as to all that I didn't withdraw, and so those are maintained.
Okay, and that's as to 15. Okay.
Yes, Your Honor.
I'll review that one.
All right, and then 19 through
through 20.
through 21. I think you had an objection because you thought it was a preview of the MSJ. Is that correct, Pablo?
Yes,
Oh.
we maintained our objections from 19 through 21.
Okay.
Okay.
And then next was 28.
What happened from 23 to 27?
I'm sorry, no, 19 to 21. We need the court to rule on those.
Mm-hmm.
And then 23, Pablo, I didn't have it one way or the other. We talked about that, but I don't know that we had an agreement. So I don't know what your feeling is on that.
We maintained our objections for attorney-client privilege and work product privilege. I think we maintained our objections to all those because it seeks subrogation correspondence.
Is that 23 through 27? Or is that just 23? What are you referring
Yes.
I think that's 23 through 28.
Was that correct, Mr. Lopez?
Your Honor, I think it's 23, 24, and then 25 deals with the consumption of Kristen Olivo's alcoholic beverages.
Mm-hmm.
So I don't think I think we dealt with that by agreement. But so my objections were maintained as to, and we would request the court to rule on 23, 24.
Mm-hmm.
Right. I don't think 20. Yeah, I think that's correct.
Yes.
Got it. 25?
25.
Big, overbroad, ambiguous, and limited in time and scope.
Yeah, I think I don't know if you withdrew those or not. Obviously, we're seeking any evidence that would indicate that Christian Olivo had consumed alcohol that evening, Your Honor, and these are kind of boilerplate objections, so we think they're waived, and the material being requested is precisely what this case is about. Was this individual impaired, and was that the cause of the accident?
Mm-hmm.
So yeah, and the agreement was we would also request the court to rule on 25, Your Honor. So we maintained our objections.
Okay, next.
Let's see here. 28, I believe, is the next one, and I think you all maintained your objections on that.
What
Well,
happened to
sorry,
26
just
and 27?
yes. So for 26, Your Honor, it deals with
Oh, I'm
I don't
sorry.
think, yes, for 26, it's also goes into one of those, the request for protection that deal with a preview of an MSJ. So we would also ask the court to rule on 26.
Mm-hmm. 27?
27 as well, Your Honor. We stand on our objections to that one.
Mm-hmm. So is the list that you all have an agreement on shorter? And can I assume that anything that is not agreed to that I need to rule on, can we maybe do it like that?
Maybe, yes, Your Honor. I'll just look through that. We've got the so 32, 35 are agreed to. He's withdrawing objections.
Yes.
Okay.
And then 36, we needed the court to decide.
Okay.
So we maintained the overbroad and we withdrew the rest of them.
What number are you talking about?
36, Your Honor.
Have you, well, see, Have you supplemented responses, or you just did some kind of Rule 11 agreement letter type thing, or how are you all memorializing this other than this hearing?
We were going back and forth on our emails, Your Honor, and there was a little confusion, and we ran out of time. So by submitting the order, we just figured we would announce our record. I figured we'd announce our agreements on the record through
Okay.
via your order, and then let
Okay.
you know what we needed assistance of the court.
That's everything through the requests for production. Now we have the
That-
interrogatories.
That's correct, Your Honor. I'll go through what we agreed to. Let's see. Number 6, we agreed to. Plaintiff will generally state and describe her activities the day of the accident, prior to the accident. That's number 6. And then number 8, Pablo, I think you were thinking about that, and according to the email, I don't think you'd made a decision yet.
We move for number 8.
Yes,
Yeah, we
number.
What did you say, Mr. Lopez, about number 8? I don't know if you finished a sentence.
It broke up.
Oh, sorry. For number 8, yes, we would maintain our overbroad, but otherwise produce. And then some of those, if there is work product privilege,
This is what I'm going to require because, we're piecemealing some of these now. So for any objections that I need to know exactly what the objections are, because if not, I'm referring to the old document and I'm not going to go back and forth and look at my chicken scratch and see which ones, well, we would do this one, but we're still maintaining these. I need a document that tells me exactly when I am going to rule on this, what your objections are. Okay.
yes, Ron.
So yeah, this is getting a little messy, but I'll continue to listen. So.
And I apologize for that, Your Honor. Yes.
9 is agreed to, Your Honor. We agreed to limit it to crimes of moral turpitude and felonies within 10 years.
See, and those types of things, I understand that you're discussing them here, but if it's not memorialized on an actual request, then this is a lot of patchwork here. And so I think there should be a document that has all of these things in it. Okay, so, all right, 9 is agreed to. What's next?
10 and 11, we need the court to decide. 14 were agreed to.
So am I to assume that 12 and 13, you still need, you're urging all of your objections and you need more?
Yes, Your Honor. I'm sorry. I'm trying to focus on the ones that are agreed to.
Okay, well, let me go back because 6 was agreed and 8 was agreed. 7 and 8 are not, correct?
See, 6 was agreed. Was 8?
Yes.
Okay.
8 was agreed. Okay, so what about 9?
No. Was 9 agreed? Yeah. Yes, 9 was agreed.
Yes, 9 was agreed.
10 and 11 were not.
Okay.
13, I don't know, Pablo. If you've got notes on that.
So 12 was not agreed, so we would ask the court to also rule on that.
13?
13 was not agreed. We would also request the court to rule on that.
14 is agreed. Next. That's everything?
Yes, Your Honor.
Okay.
Yes, Your Honor.
Did you have anything for the court on those? If not, just gonna review them in light as I best can with your tweaks today. Anything else on those?
I think, Your Honor, I think the motion itself clearly states our position on these with regard to the applicability, and I think we did spend a good long time talking about this, and plaintiff. I think plaintiff dealt in good faith, but we just require assistance of the court on the ones that were not agreed to, Your Honor.
Sounds good. All right. And then Mr. Lopez, also you had a motion to compel as well?
Yes, Your Honor.
Okay. Is there a similar order?
No, I would submit one to the court, Your Honor, to deal with the specific ones that we moved in our motion, because Mr. Mason did supplement his discovery. And so we amended our motion to compel to deal with those requests for production and interrogatories. So they're way more limited.
Okay. You filed
and so
an amended motion to compel?
Yes, Your Honor.
Okay. When did you file it?
On April 2nd,
Okay, let me look at it.
Thursday.
And maybe, Your Honor, we can do the same thing with the order, and that he and I can agree to it, sign it, submit it to you, because there are a few things that we agreed to on that motion as well, just so we don't overburden or overtax the court, because I know these can be tedious.
I'm sorry, you said April, oh, there it is, April 2nd. There's one on April 2nd and one on April 6th. Are they the same document? Plaintiff's amended motion to compel discovery. It looks like it's the same document. Okay.
Oh, so Your Honor, the April 6th one is Mr. Mason's response to my amended motion to compel.
No, there's two
So
motions to compel with the same title. One is on April 2nd and one is on April 6th. Plaintiff's amended. Motion to compel discovery of defendant Rico Spirits LLC. Okay, so your amended motion.
Yes, Your Honor.
And we did, yeah, we filed our response on April 6th, Your Honor.
Got it. Okay. So where are you all in agreement here? Oh,
So I will go first, Your Honor, with the interrogatories, and Mr. Mason, please correct me if I'm wrong, but for the motion to compel that we moved on to interrogatories, we moved to compel 3, 4, 5, 7, 11, 12, 13, 14, 15, 16, 17, 18, and 19.
okay.
For 3 through 5, 3, 4, and 5, we've agreed to that. So,
And Your Honor, it may be really helpful at this point, because I don't think this is explained in the response in detail, but the affected requests on most of these deals with conversations and related material between Christian Olivo, who is a defendant in this case, and his father, who is the principal of Rico Spirits. His father is a licensed attorney and a former judge. His father got an alert on his watch that his son had been in an accident, and there were communications between the father and the son specifically about the accident, about his dealing with the police. It's all attorney-client privilege, and I certainly understand that the plaintiff would like to have that, but it's just classic attorney-client privilege. His father was acting in a attorney capacity by advising his son, who is involved in this accident. So that's what a lot of both the interrogatories and the requests, not all, but several of them, and the interrogatories, requests for production, deal with that material, and it's just absolute attorney-client privilege.
So let me go back. I thought I heard you say, Mr. Lopez, that 3, 4, and 5 were already agreed.
yes, Your Honor.
It
Okay.
is it agreed as
And
to if we will respond as generally, and they agreed to remove the describe in detail. So that's how we'll respond, Your Honor.
So then the remainder of the interrogatories listed on plaintiff's amended motion are not agreed? Or are there any more that
No,
are agreed?
oh, no, Your Honor, I didn't have a chance to finish on what we agreed. Really, what the other interrogatory that we agreed to was 11, and it was also the same agreement that we would amend the interrogatory to say generally, and they would supplement. Other than that, Your Honor, we would ask that the court rule on the interrogatories.
So 12,
Or
13, 14, 15, 16, 17, 18, and 19, correct?
Correct, Your Honor.
Okay.
yes, 7, 12, and then 13, 14, 15 through 19. Yes.
Okay.
With 13, we did amend for 10 years. And Your Honor, specifically with what Mr. Mason mentioned about the attorney-client privilege, we understand how delicate that is, and it is not our focus to request attorney-client privilege. To the extent the conversations, because Mr. Olivo, the father, he's the owner of Rico Spirits and has the employee, his son, who deals with the marketing, and he was at the event in question, Your Honor. And so what I'm getting to is the conversations prior to the accident and whether those conversations happened, how the event go, who went to the event, where are you going next? Hey, I need you to go deliver these bottles. All of those, Your Honor, are not attorney-client privilege because the accident had not happened. And so there was nothing to be, there's no privilege. And to the extent Your Honor thinks that is privilege, we would ask for an in-camera review of those conversations so that Your Honor can determine whether there's an applicable privilege for those conversations. Because
So when you're talking about those details, not talking about the in-camera review stuff, is that articulated in your interrogatory? I mean, does it specify that, or is the language in your interrogatory more broad?
It's go ahead, Pablo. Sorry, I didn't mean to interrupt.
So the interrogatory, Your Honor, is deals with conversation. So for example, let's see. So for example, number 14,
Mhm.
that to describe the conversations between Mr. Olivo, between defendant Rico Spirits and defendant Olivo from February 1st, 2025 to March 15th, 2025. And what I'm trying to get to, Your Honor, is to deal with the planning of the event. Mr. Anthony Olivo lives in Austin, Texas. And so the travel arrangements, hey, yes, Rico Spirits will reimburse you for the gas to this event. All those conversations that deal with and build up to the event, Your Honor.
Mhm.
And the problem with that, Your Honor, and the reason we objected as that being completely overbroad and on a fishing expedition is because this is father and son, and the way that it's crafted, we have to disclose all the communications between father and son for a month. It seems like that it is overbroad, too overbroad for an interrogatory or request for production. This is going to be best handled in a deposition, which clearly we're going to present our principal in, and then these questions can be tailor made. But as they are written, Your Honor, they're just impossible to respond to.
Okay. All
Your
right.
Honor, we do, so 14 is limited to the attendance of the tequila tasting event and
But
consumption of alcohol.
does the interrogatory say that? Does it say that? Yes?
Yes, Your Honor. Including but not limited to his attendance to the tequila tasting event, his duties and responsibilities at the event, his consumption of alcoholic beverage at the tequila tasting event, and to the extent that goes into after the accident, I agree that would possibly be subjected to attorney-client privilege. But to the extent they're talking about, hey, yes, I drank 2 shots at 5 p.m. or at 7 p.m. before the accident happened, there's nothing to be protected there because they're not communicating with the expectation that there's an attorney or that there's a claim to be protected for.
But Your Honor, it's inclusive and not exclusive. It says including, but not limited to, and then it's what he really wants. And so as written, it's not only what he really wants, but it's everything else in the kitchen sink for a month. And that's the problem. It's not tailored.
I'll review it. What else?
Okay. So that's it, Your Honor, for the interrogatories. We submit for you to rule on the rest of them.
Okay.
And to the extent, Your Honor, okay, yeah, I'll move on for the request for productions.
Okay, go ahead. Any agreement?
Yes. So for the request for production, the plaintiffs moved to compel defendant Rico Spirits to produce or withdraw the objections for 1, 2, 5, 6, 8, 11, 14, 18, 19, 21, 23, and 24 of Rico Spirits' amended production of documents. And for those, Your Honor, we've agreed to 2, 6,
Mm-hmm.
2 and 6.
Great. Anything you want me to know about the remainder?
Yes, Your Honor. So for these, again, they deal with Mr. Olivo, the driver of this of the Tacoma that was involved in the front end collision with my client, had, upon information and belief that we have, is that he was transporting tequila bottles, whether they were samplers or not, and so he had tequila bottles in his vehicle at the time he was arrested.
Mm-hmm.
He was also arrested for intoxicated assault with the vehicle, and he's facing criminal charges, but he had those tequila bottles, which we don't know what tequila bottles they were for. We don't know if there were tequila bottles for Rico Spirits, whether they were for Tequila General, or whether they were for Don Vicente Tequila. And so these requests, we also want to know the extent and the scope of Mr. Olivo, the driver, of his duties and scope of employment. We ask for payment, for example, Your Honor, on request for production number 8, Your Honor.
Mm-hmm.
We ask for payments, payment structure, compensation, or benefits that Rico Spirits provides to Christian Olivo. We want to know if he was reimbursed for gas for that day, or if he was allotted $50 for meals or $50 for the tequila bottles to take to the event. All these are relevant questions because they deal with their stance is we didn't sponsor, we didn't promote, or we didn't market this event. We were just invited. But we want to go and see, Your Honor, because there's an ad that was shown on Instagram that shows the tequila tasting event and the 3 tequila companies as the tequila sponsors for that event. And so we want to know how did that come to happen? Whether they had to pay the restaurant to host that event, whether they were paid by the restaurant to host that event. And as far as mileage, Mr. Olivo, Christian Olivo, he drove from Austin, whether he was reimbursed by his company for the mileage to attend the event, whether he was giving gas money or whatnot. And so so all those, for example, for number 8, all those we believe are relevant because they're going to show whether he was actually compensated for this event in question.
And Your Honor, had it been requested in that fashion, that would be correct, but it's not. It's asking for all documents, compensation, benefits from March 1st, 2024 to the present. So this is well post-accident. They want, and then they specify payroll records, W-2s, 1099s, commissions, bonuses, expense records, et cetera, et cetera. What that has to do after the accident, Who knows? It has nothing to do with it. So again, the intent is there, and I think that the plaintiff knew what he really wanted, but these are all crafted in such a way that to respond to them, you have to bring in all this irrelevant information. What he's earning today, a year after the accident, what does that matter? His financial privacy and his W-2, how does that affect or impact the question of whether or not he was negligent on the evening of the accident? His pay today, what does that have to do with it? So that's the problem, Rob.
Well, but Mr. Mason, then are you saying that, you're not objecting to things that are up until the date of the incident?
No, I'm not saying that either, Your Honor. What I'm saying is it is so overbroad I'm saying there are certain things that might be appropriate to produce, but his payroll records and W-2s, that's got nothing to do with his accident. Nothing, whether it's before or after the accident. But as presently written, this continues a year beyond the accident. So that's certainly not. I think if plaintiff recrafted these and was very selective with what he really wanted, then that would really help the case. But all of these, Your Honor, are in such a broad manner that I have to object and produce subject to the objections, and that's what we've done. I mean, we have provided the documents on most of these that we have. There's a few, he wants all the financial information about the company. He doesn't get that. He's, before that ever happens, he's got to get a judgment. So that's not, but K1s and W-2s and tax forms for spirits. So some of this is completely overbroad, and then some of it is overbroad, but it does contain some things that would be relevant, and we've produced those, Your Honor.
Okay. Anything else, Mr. Lopez?
Your Honor, and in addition to that, just and I'll be short, just to get your attention to this request, Your Honor. For request number 11 as well, we're asking for the communication between Rico Spirits and the rest of the defendants regarding this event. I want to know whether they and how they plan to have this event, who organized it, when did they organize it, who was going to sponsor this, who was going to pay, who's going to be responsible for taking the bottles, for taking the food, for inviting people, for taking the glasses. All these things are relevant to the event in question because they consumed alcoholic beverages as are seen in pictures. And so we want to go and see, the communications, whether they're on their Instagram pages, because all these companies have Instagram pages that promote and advertise tequila, including, Your Honor, the event in question.
And Your Honor, just to respond, and again, the way it's written, it's going to include discussions between the father and son, which are attorney-client privilege. I'm happy to respond to this and even modify it, and even because there are none. We didn't plan it. We just showed up and we reposted the poster on our Instagram. That's it. That's our complete involvement in this entire thing. And I'd love to say that, but because of the way these are written, I can't. I can do that, but I have to do it subject to these objections because I can't waive the attorney-client privilege between the father and son.
All right. What else, Mr. Lopez?
Your Honor, and we would agree to limit the request to immediately prior to the accident.
And so that's the sort of thing we can respond to, Your Honor. And I think to plaintiff's satisfaction.
That's it, Your Honor. The rest of them, like I said, number 1, 5, 8, 11, 14, 18, 19, 21, 23, and 24, we would ask the court to rule, and I would submit a proposed order for that, Your Honor.
Please go ahead and submit it quickly so I can take care of those.
Yes, Your Honor.
All right. Anything else on those two motions to compel?
No, Your Honor, I think we've covered everything.
Thank you. Okay, so we have a few other matters today, and we're running short on time. So Let me see. Mr. Del Campo, were you a sub-in? Who subbed in on the motion who subbed in on the motion? There was a motion to substitute, motion to withdraw. I thought it was Mr. Blanco.
Yes, Your Honor, it was our firm. We are for Ye Group.
Okay, okay,
Your Honor, I'm here on behalf of Mr. James Martinez.
got it. So what I had left over from the last hearing was the attorney's fees on the motion to dismiss. And then I think Mr. Lopez had asked for a continuance on his default.
Oh, Your Honor, we withdrew the default.
Well, that's
And
what I asked last time, and I assumed it was completely withdrawn, but then you turned around and said, no, you wanted it reset.
we withdrew we reset it, Your Honor, so we could engage in conversations with Mr. McLean because he's here on behalf of P.L. Howard.
Mhm.
And as of today, we filed a notice of non-suit as to P.L. Howard.
Okay. So I don't know that I need an order, but if you have an order, send it.
Yes, Your Honor. We'll submit it.
Okay. So the attorney's fees? Mr.
Yes,
Lopez?
Your Honor.
And that's your client, right, Mr. Keim?
Yes, Your Honor, that's correct.
Okay.
So, Your Honor, may it please the court on the motion to recover attorney fees. 91A7 is clear that the prevailing party on a 91A motion to dismiss may recover attorney fees for the prevailing party. And when Ms. Olivo filed this motion to dismiss the 91A, not only was it untimely filed, it was filed approximately 30 days after the deadline to file the 91A, but it was also not a proper motion to file at that point. There was plenty of claims and asserted facts that would give her a reasonable chance to know that she was being sued and how she was being sued and why she was being sued in her capacity. There's also, and you know, the 91A doesn't go into the evidence, but there's pictures of her attending the event, leading the event, teaching people how to taste the tequila. And so the motion to dismiss, the 91A motion to dismiss, was filed improperly. And for that reason, Your Honor, we asked to recover attorney fees. We also submitted, Your Honor, an affidavit as to the reasonableness and necessity of defending Ms. Olivo's 91A motion to dismiss, which was attached to my motion as Exhibit A. We did a motion in support. And so for those reasons, Your Honor, we ask that the plaintiffs awarded attorney fees because of Ms. Olivo's improper 91A motion.
All right, Mr. Keim, you going to respond?
Yes, please, Your Honor.
Yes, sir.
So basically, to start off, Your Honor, I would point to Rule 91A specifically. Now, what that rule says regarding attorney's fees for the prevailing party exactly is that courts may award the prevailing party all costs and reasonable and necessary attorney's fees incurred with respect to the challenge cause of action. Now, it's really important. It says may, does not say shall. So what we're looking at here is a discretionary fee shifting provision. Ultimately, Your Honor, you have absolute discretion here on whether or not to impose this fee shifting as requested by plaintiff. Now, just to give some background why things occurred the way they did, obviously, we're aware at this point that there was a car accident, there was a DUI involved, there was injuries, and so I won't get too far into that. I'd just like to focus in on my client and her circumstances and what led to the motion to dismiss being filed. So Miss Olivo used to live in El Paso, is from El Paso, now lives in Washington, D.C. On the weekend of March 15th, there was a bachelorette party. She came to El Paso to I guess, attend the bachelorette party. She's also very into tequila, and one of these tequila companies is owned by her uncle. Her cousin works there, and so she attends this tequila tasting event. She wasn't involved in it. She didn't organize it. She didn't plan it. She didn't work it, but she was there. She attended. She leaves around 5, and then naturally, as we all know, about 6 hours later at 11, this car accident happens. So we get to the point where she's pulled into the lawsuit. Obviously, she's wondering, what the heck is happening? Why am I here? And I've talked to her a little about it before to get her mind on why she did the motion to dismiss. And Your Honor, I got to tell you, she really impressed me in that regard because she was reading the rules of civil procedure. She was really trying to do this right. And she said, I thought maybe a summary judgment would be more appropriate, but then I saw this provision that adequate time for discovery. And so that's where she's at. She wasn't trying to engage in any gamesmanship. She wasn't trying to harass the plaintiff, drive up costs. Uh, she was trying to make what legitimately seemed like a good faith argument for a valid request. And for that reason, Your Honor, looking at the facts and circumstances here, in light of the fact that we're dealing with a discretionary fee shifting provision, I just don't think it's warranted to impose what is essentially a sanction on Miss Olivo. I think the legislature made this discretionary for a reason, and the reason being that naturally there's some situations where this is warranted, there's some situations where it is not. And Your Honor, I would assert that this is a situation where the fee shifting of attorney's fees it just is not called for. Now, the second thing, to the extent, because as I discussed earlier, it's your discretion completely. To the extent you'd like to exercise that discretion to award plaintiff attorney's fees, I would assert next, Your Honor, that there's just insufficient evidence for any fee award, much less the fee award requested. Now, the first thing I'd point out is that Rule 91A allows fee shifting for attorney's fees incurred. Now, if we look at the only evidence that was submitted in support of the request, it's just a conclusory affidavit. There's no billing statements, there's no contemporaneous time records, and so there's really no evidence that this claimed fee has actually been incurred. And as a result, I'd submit that we're running the risk of a windfall here. Now, next, if we look at the seminal cases on attorney's fees being Arthur Anderson, Rormos, and even at the commission, the pattern jury charge, right? There's factors that we look at to determine whether a claimed fee is reasonable and necessary. And to me, the most important ones under these circumstances are the time and labor required, the novelty and difficulty of the questions involved, and the skill required to perform the legal services. The next being the fee customarily charged for similar legal services. And finally, the experience, reputation, etc. of the lawyer performing the services. Now, essentially, Your Honor, what I'm saying in this regard is that plaintiff, through the evidence submitted in support of the request for attorney's fees, has not established that these fees that she's seeking to recover were incurred. The affidavit states an hourly rate of $300 for Pablo Lopez. I would assert that that's not reasonable or reflective of prevailing market rates for attorneys with around a year and a half in experience. And finally, the affidavit says about 7 hours, 45 minutes opposing the motion to dismiss. But what the affidavit does not say is any justification as to why the issues presented here were so great and complex to warrant that much time. With that being said, Your Honor, I just think even in the event that you'd like to award plaintiff attorney's fees here, the evidentiary burden that plaintiff would have to overcome to be entitled to that recovery just has not been satisfied here. Thank you, Your Honor.
Mr. Lopez.
Your Honor, I would just point out to a couple of the cases that Mr. Keem cited to in the response, and a lot of them deal with contractual attorney fees disputes. So, for example, Ramos that deals with section 380018 for the fee recovery under the Texas Civil Practice and Remedies Code. They don't deal with and talk about 91A7. Further, those cases deal with attorney fees for $1 million, and they're talking about the unreasonableness and conclusory allegations as to those attorney fees, and do not talk about the fee shifting provision 91A provides. This motion was filed 34 days after the required period. It was filed not only late, but also it was unfounded for, Your Honor. There was plenty of assertions in plaintiff's petition and even in defendant's motion to dismiss that admitted that she was at the event, that she was that she has the tequila, La Tequilana, which is her Instagram panhandle for the tequila tasting hosting that she does. It's a service that she does. And so she was sued in her capacity as La Tequilana and individually. And so for those reasons, Your Honor, we submit that the attorney fees and the affidavit are proper. They state and lay the reasonableness of the attorney fees, and further the hours spent not only drafting but researching and attending the hearings.
All right, yes, the court is not inclined to grant those attorney's fees at this time. Thank you very much.
Thank you, Your Honor.
What is left on this one? Is that everything? I have a little note on a motion to dismiss, and I'm looking at the events, and I don't see another motion to dismiss, so I'm wondering if that's a typo. Mr. McLean, I think you're good to go. I just saw the non-suit was part of the Odyssey entry for today. I can't see the non-suit, but it's there. So
I did see it, Your Honor. Thank you.
thank you.
Have
What
a good
else?
day.
You too. What else is left?
I think that's it, Your Honor.
I know what's left. We don't have a scheduling order. We don't have a trial setting. That's what's left. We're not set for a scheduling status conference, but would you all agree with me? You want to just take advantage of today to get a trial date, or is there some reason I'm waiting?
No, absolutely, Your Honor.
We didn't talk about this last time. I feel like we did, but maybe not.
I was
All right.
thought something was getting kicked around by us. Was there any email on this entering a DCO?
I don't think there's been an email regarding a DCO.
Yeah, okay. We certainly should do one.
So we're looking at June 4th, 2027, pending Ms. Nieto, if you're there, telling me if I'm wrong.
That's correct, Your Honor, June 4th.
Yay! Anyone have a problem? I feel it was a busy day the last time you guys were here too, so I could have been talking to some other folks.
Your Honor, without objection, we can submit a circulated DCO amongst us. I'm sure we can come to dates on everything else with that trial date.
As long as I'm not hearing any issues with that date, then yes, please include your agreed to mediator. Turn in your scheduling order before the entry date, and you don't need to appear. Yeah, because we don't have any dates. Also, I'm not seeing anything else. Okay, just know if there's something that requires a hearing, please submit your request with Ms. Nieto and we'll get you scheduled outside of the dates that are on the scheduling order. Okay? All right.
Thank you, Your Honor.
Thank you for your time, guys. Have a good day.
Thank you, Your Honor.
Thank you, Your Honor.
Bye-bye. Okay, I have a feeling, let's bring in Mr. Almanzan and Miss. It says status conference. Oh, let me bring them in. It says status conference, but I feel like this is the second time we've listed them as status conference, and it's not a status conference. Mr. Almanzan, how are you?
Hi, Judge. I apologize for this casual. I'm actually driving back to I'm not driving, but I'm in a vehicle coming back to El Paso right now. Forgive me.
No worries.
I do have my colleague Nathan De Silva on the line as well in case we're going to have a hearing.
I was just commenting because I saw you all in the waiting room and I saw Ms. Tawari in the waiting room, and I said, this is supposed to be a hearing. And it says status conference.
It said status. It did say status.
Why does it say status? Why are we at a because that was the issue last time.
Correct.
Correct, Your Honor.
So what I'm going to say is this. Because I feel like that's the court's error, I'm happy to proceed. Let me just let Odyssey load up on what we were supposed to hear since last time. So I'll take my cue from you all. And
I
if
believe,
not, we
yes,
need to
I
get
believe
actually
we
get
are
it set. You
right.
ready?
It's whatever council would like to do. We're happy to have it heard during this Zoom, or we can reschedule it. It's up to council's preference as well, Your Honor.
Ms. Tawari, talk to me.
Your Honor, we can proceed with the hearing today. We're ready to go.
Okay, so let me load it up. And again, I apologize for that. Let me see. Yes, so it was filed since February 11th. This is, wait a minute. Hold on. It's the wrong document. There it is. Yeah, no, that's the right one. Okay. Okay, so council, let me go ahead and call it. All right. Okay, calling cause number 2025 DCB 2036, Angeline Michaela Harpoon versus Transportadora Norte de Chihuahua et al. May I have announcements, please?
Attorney Pooja Tiwari for plaintiff.
And Your Honor, this is Andres Almanzan and Nathan Da Silva for defendant Transportadora de Chihuahua. And we are also special appearance counsel for the driver as well, Your Honor.
Okay. And as we were discussing briefly off the record, we were only set for the status conference today, but by agreement of the parties, the scheduling issue with for the court was that this wasn't actually set for hearing, but I think everybody was on the same page with the idea that it was intended to be heard today. And so let me see, I have, this is the first amended, the first amended, Jose Monreal's verified first amended special appearance. Let me make sure, let me just go back. Mr. Almanzan, is it you or Mr. Da Silva?
Mr. Da Silva, fortunately, like I said, Your Honor, forgive me, I'm in a vehicle, not driving, but I'm being driven right now. But Mr. Da Silva is prepared to present the first amended special appearance argument on behalf of Mr. Monreal.
Thank you very much. Mr. Da Silva, go ahead.
Yes, Your Honor. Good morning.
Good morning.
With this special appearance, we have two issues to tackle today. The first of which is whether an error in a special appearance, and in this case, that was the lack of verification from our original prior to this amended version, whether that can be remedied by an amendment. And I can tell you that it can and it has. Now, first off, Rule of Texas Civil Procedure 120A does state that errors in a special appearance can be remedied by an amendment. And this has been, again, affirmed in the Texas Supreme Court in the case of Dawson Austin v. Austin, where the court held, and I'll quote that right now, that the rule does not limit the kinds of defects that can be cured. The absence of a verification is such a defect, and an amendment that adds a verification cures the special appearance. Now, we have already amended this, added the verification well prior to this hearing, so that should not be an issue any longer. Any issue that might have arisen from not being verified has been cured by this amendment. Now, the second issue that we encounter is more complicated, and that is whether the plaintiff can obtain jurisdiction for the court over a Mexican national living in Mexico by following the Texas long arm statute to serve the Texas Transportation Committee chairman. And now the issue with this is that the service of Mexican nationals in Mexico is governed by the Hague Service Convention, which is a treaty that is signed by both the United States, Mexico, and many other countries that governs service on foreign defendants. And this service convention preempts federal and state law, and I'm going to get more into that. But first, I'll ask Your Honor, would it be all right if I provided you with some background for this case?
Sure.
All right, just very briefly, this case arises from plaintiff's alleged collision with a vehicle that was allegedly driven by defendant Jose Monreal. According to the return of service that was filed by plaintiffs on October 13th, 2025, she served the Texas Transportation Committee chairman under the Texas long arm statute to effect service on defendant Monreal. Now, as I said before, the issue is that Mexico access to the Hague Service Convention in 1999. And where the Hague Service Convention applies, that is, in any case where service has to be transmitted abroad, it preempts federal and state law. This was held by the United States Supreme Court in Volkswagen v. Schlunk. And in that case, they stated that as long as it applies, then all state manners of service and federal manners of service are beholden to the Hague Service Convention under the Supremacy Clause of the United States Constitution. It preempts federal and state law. Now, the issue that arises from there is whether it applies in this case. And plaintiff has actually relied on Volkswagen v. Schlunk, the case that I mentioned before from the United States Supreme Court, to make the argument that it does not apply here. Now, in Schlunk, the United States Supreme Court found that it did not apply, but the facts of Schlunk are very different from what we have today. In Schlunk, Volkswagen, a German company, had a wholly owned domestic subsidiary in the United States. And the court held, well, you have a wholly owned domestic subsidiary, you effectively designated someone for service of process. This is sort of your foot in the door. Well, we're serving you through the foot. They said that at that time, it does not require transmission of service abroad because they're going to serve the domestic wholly owned subsidiary. Defendant Jose Monreal does not have a domestic wholly owned subsidiary. And plaintiff has instead alleged that, well, the Texas Transportation Committee chairman is his agent for service of process because that's what the statute says. Now, first, that does take away the element of choice that was important to the court in Schlunk as well, that there Volkswagen had chosen to create a domestic wholly owned subsidiary that was its agent. It had actively put itself in a position to be served. However, here, defendant Monreal has not done anything that puts him in a position to be served through the Texas Transportation Commission. He has not made any indication that that is his agent for service of process. This statute is completely separate from him. However, even beyond that, another issue addressed by the Hague Service Convention is something called notification a parquet. Now, notification a parquet is the practice where a domestic official can be served for the purpose of serving a foreign defendant. And the idea is that you serve this domestic official, and that's the date of service, and then the domestic official goes through various processes to serve that foreign defendant, to effect service on, to transmit it abroad. Now, that is dead on exactly what goes on with the Texas long arm statute and the transportation committee chairman. When they serve the chairman will then go on to send this, ideally, although we don't have verification that he does, the defendant will then attempt, or the chairman will then attempt to serve through the mail the foreign defendant. Now, the United States Supreme Court in Schlunk said that there is no doubt that the Hague Service Convention was intended to eliminate notification à parquet. They stated specifically that their holding in Schlunk does not extend to notification à parquet. So what we can see there is that this is a situation where transmission abroad is occurring. It may be that we're handing it to the chairman to transmit it abroad, but it is well within the understanding of the convention and of the United States Supreme Court that that is a situation where the Hague Service Convention applies. And if the Hague Service Convention applies, then the only method of service available is by serving the Central Authority of Mexico. And the reason for that is that when Mexico accessed to the Hague Service Convention in 1999, they made various declarations, and one of which was that, in effect, this is not their exact words, but it has been interpreted this way by courts, all other methods of service are not allowed aside from service through the Mexican Central Authority. Now, I can tell you that that comes in components of that may not be served by a domestic official, the state of origin, that that is going to serve it on a official of the state of destination, and it also specifically objects to service through the mail. So in this case, certified first-class mail has already been specifically objected to by Mexico. So the bottom line to this is that Hague Service Convention does apply, and based on the declarations Mexico made when it accessed to the convention, it will absolutely not accept service through the Texas Transportation Committee chairman that then goes, even if it went to the Mexican Central Authority, because that is not the same as what they're asking for in the Hague Convention. Now, just to round that out, another thing that we have to consider is that it is always the purpose in interpreting a treaty to affect the purposes of that treaty, not just to follow the form of it. And what we can see here is that this absolutely would be contrary to the purposes of the Hague Service Convention. If we allow plaintiff to make an end run around the processes in the convention, then what we're seeing is not, not the due process that Mexico and the United States have agreed to, but a shortening that just shortcuts and takes away from what Defendant Monreal is entitled to under this treaty, which includes service through the Central Authority and translation into Spanish, which has not been shown to have happened for the petition that was sent even to the Texas Transportation Committee chairman. So for those reasons, this special appearance is, we ask that it is, granted, in that the court cannot obtain jurisdiction over Defendant Monreal until the Hague Service Convention has been followed to the letter.
Yes, sir. Thank you. Ms. Tawari.
Good morning, Your Honor. In our response to defendant's special appearance, our major arguments are twofold. First is, when we filed a response at that time, defendant's special appearance did not comply with Rule 120A1 of Texas Rules of Civil Procedure. I think this is mentioned by Counsel De Silva, since it was not a sworn motion at that time. I believe Defendant Monreal has since we filed a response. They've cured this defect in their first amended special appearance. Our second argument with respect to Defendant Monreal's special appearance is that service on chairman of Texas Transportation Commission is proper under Texas long arm statute. Your Honor, Section 17.062 of Texas Civil Practices and Remedies Code, it states that chairman of Texas Transport Commission is an agent for service of process on a person who's non-resident involved in a collision while operating a motor vehicle in the state, but who subsequently moved out of the state. That is exactly the case here. Defendant Monreal was operating a motor vehicle that was involved in this collision with this plaintiff. And, subsequent to that, defendant Monreal has moved to Mexico. Further, Your Honor, Section 17.063 of Texas Civil Practices and Remedies Code states that a certified copy of process must be served on the chairman. Immediately after being served, the chairman would send the notice and copy of process to non-resident by registered or certified mail. Your Honor, that has been done in this case, per Exhibit A to plaintiff's response. We have a copy, we have a certificate from the chairman of Texas Transportation Commission, which states that, it was served on him and that the chairman immediately, served the citation and a copy of plaintiff's original petition via registered mail addressed to defendant Monreal. Further, Your Honor, Section 17.063D of Texas Civil Practices and Remedies Code states that, after chairman deposits a copy of process in the mail, it is presumed that the copy was transmitted by the chairman and received by the non-residents. Your Honor, it does create a rebuttable presumption that the copy was received by the non-resident once the copy of process is transmitted by the chairman in the mail. Further, Your Honor, Section 17.064 of Texas Civil Practices and Remedies Code states that service on chairman has the same effect as personal service on non-resident. Your Honor, it is our contention that, that service on the chairman of Texas Transportation Commission has the same effect as personal service on defendant Monreal with respect to Section 17.064 of Texas Civil Practices and Remedies Code. With respect to the argument on the case Schlunk, which was held by Supreme Court of, United States Supreme Court, we do concede with defendant's argument that it is distinguishable on the facts of this case because the United States Supreme Court did not rule whether the convention applies to notification of parquet. In the alternative, Your Honor, I also request your court, and I believe I've also included that prayer in our response, that if this court does require a service on defendant Monreal through Hague Convention, we request additional time for the same. We have, in our due diligence efforts, tried to started the process to serve defendant Monreal through Hague Convention. The latest update that we have from our process server with respect to serving defendant Monreal through Hague Convention is that they have served a Spanish and English copy of a citation and petition to the Central Authority in Mexico on 27th March 2026. However, our process server has also mentioned that the service via Hague Convention has a minimum turnaround time of about 6 months, Your Honor. We just request, if Your Honor does hold that Hague Convention, that service on defendant Monreal is required through Hague Convention, we, in addition, just need additional time to do that.
Okay. All right. Anything else? Mr.
Your Honor, if I could briefly...
Mr. Wary, if you were done. Yes, I'll hear a response.
Yes, Your Honor, I'm done.
Thank you.
If I may briefly just respond, Your Honor. Just a couple of comments. One, as I said before, and I can pull the section of the Hague Convention that allows for this, Mexico did make very thorough objections to any other form of service. And one form of that service would be if just service through mail. So if the Texas Transportation Committee has served the defendant directly through the mail, that's not allowed under the Hague Convention. And furthermore, that doesn't really provide for the due process considerations that are within the Hague Convention. You know, that one, that it be translated, and two, that it go through the Mexican government to make sure that they are in agreement with all the processes involved. And we've agreed to this treaty, and it really does have a preemptive effect on any of our laws regarding service. So upholding those promises, I think, is of the absolute utmost importance. And beyond that, if we don't, the Article 15 of the Hague Convention states that no judgment shall be taken prior to compliance with the Hague Convention, meaning that any judgment that would be taken without following that first is going to be brought up on appeal as, you know, hey, didn't follow the Hague Convention. This never gained jurisdiction over them, and we might just have to kick it all back down again. So I think that is a really overwhelming reason not to cut corners on this convention.
All right. Okay, counsel, is there anything else on this?
Nothing
No?
further, Your Honor.
Ms. Tawari?
Nothing further, Your Honor.
Thank you very much for your time. I am going to review mostly your arguments today, and we'll have a ruling for you very shortly. This is also one that I think we need to schedule for a scheduling status conference in about 30 days. So you'll have a ruling well ahead of that. Okay?
Thank you, Your Honor.
Yes.
Thank you for Monday. Ms. Tawari, were you going to say something?
Yes, Your Honor. I was also saying, if in the meantime, we could just get a trial date, and I could reach out to Defense Counsel for a scheduling order, and we could file it with the court.
If
so
you'd like to handle that now, that's what I was saying. We'd schedule in 30 days, but I'm happy to do it now if you all are ready for it.
Well, Judge, that's what we're hoping. Let's do that at the proper time, which is at the scheduling conference, depending on how you're going to rule.
Right.
Obviously, Your Honor, because I think, how this next process is going to take may very well affect the scheduling of this case. It's going to be part and parcel of how we're able to move the case along. And so respectfully, Your Honor, we would like to defer that decision until a ruling has been made, and then we can move forward with the scheduling conference. And again, I didn't say this earlier, but of course the defendant would not have any objection or impediment on giving whatever time is necessary to the plaintiff to properly serve the driver defendant through the Hague Service Convention if the court is inclined to sustain the special exception. And if the plaintiff is going to need to go through the Hague Service Convention, then obviously we would not object to any additional time that the plaintiff needs and which needs to do so.
Yeah.
in that case, Your Honor, we could discuss this at the next scheduling conference.
Okay, that's what we're going to do. Thank you very much. Thank you, Mr. Armanzan, Mr. De Silva, and Mr. Tawari. You all are excused. Have a good day.
Thank you,
everyone.
Your Honor. Have a good day.
Bye-bye. So, Mr. Nanez, I see the waiting room filling up, and I can tell you we are going to be extremely busy. So does someone need a break? Mr. Walter, you want to take a break? Let's take a quick break, please.
Guys, there's going to be a lot, so at some point I might not be
I
able
know.
to sort them out. I'm just going to call them by
Oh,
order.
I know. We're going to have a lot going on. Thank you.
Yes, ma'am. It's very busy. Hello, Mr. Francois.
Good morning. How are you?
Hi. Do you have a cause number? Last four?
Yes, 1 second. Let me make sure I have the right one. I think our hearing doesn't actually start till 11:30, but I'm on Central Time and I panicked when I saw the timing, so I wanted to make sure I didn't miss anything.
Okay. 11:30?
Yes, it's last four of the cause number is 0886.
It's at 10:30 El Paso time, but
Yes.
it's going to be a while. Okay.
Okay.
If you're welcome to wait, you're welcome to log back in, whatever you'd like to do.
No problem. I'll just probably wait. Thank you very much for letting me know.
Okie doke. Hello, Ms. Zabalgoita? Goitia? Hello, ma'am? Ms. Zabalgoitia?
Hi, good morning.
Hi, ma'am. What's your cause number?
Sure, let me grab that. I'm here for two cases. I'm new with the Labinati firm, so I'm covering for Daniela Labinati.
Okay, that's fine. I'll put you down.
Okay, great. Thank you.
Hello, who is this? Erica?
Oh no, my name is Charles Sanders. I'm here for Delphia Herschel. That is, let me just check it out. Let me look at the cause number. Hold on.
I see you. 2681?
Yeah, DCB Delphia Herschel. Yeah, 2000,
Yeah.
yeah, 2681. You're correct, sir.
Thank you.
How you doing, Tony? Mr. Aguilar.
Morning, Mr. Gonzalez.
Hey, how you doing, brother?
Good, and yourself?
Come on, Nico. Mr. Del Campo. I call Mr. Aguilar because I respect him. He scares me. So.
Well, I'm afraid of you, so what do you do?
I love you. Make me work. Hey, I sent you that stuff, but I'm gonna send you some clean copies of all the deeds for our mediation. Okay.
Oh, no problem.
On that Belmonte case, I have never had to file an abstract of whatever you file.
Well, I want to save money.
Yeah, well, I think that kind of circumvents it, but I'll clean it up for you. I'll get you all that stuff. Hopefully, we'll get it resolved.
Well, yeah, we should.
And on that other case, I've been meaning to call you, but I know you've been busy too. I know you haven't called me back because you've probably been busy. But I got to get you a USB with all these paperwork on there. So,
Well, I've got to work on that other case. I
Yeah.
can't be busy.
yeah, the issues there is that third party. I found out who it was. So
Well, I gave you the time to try to find him. I mean,
yeah, we found him. I think we found him. He got indicted. He has like 15 cases. The only question is just the back in front of that check. But well, I'll call you about it.
Yeah.
I'll just send you some stuff over before I send you that. I got some discovery I got to send over to you, but I'll shorten it up so we don't try to circumvent it for the 30 grand. You know.
Mr. Nanez, are we ready on somebody?
Yes, ma'am. On
Get
page
started.
3, Judge. Let me let everybody else in, Judge.
Sure.
And good morning, Your Honor. Sorry, Judge. Good morning.
Good morning. So you all know we have a very busy docket this morning, okay? So
I'll be quiet.
I don't mean to be a Debbie Downer, but we got a lot to get through today.
Good morning, Your Honor. Can you hear me?
Yes, sir.
Okay.
Where are we starting, Mr. Nanez?
Judge, on page 3,
Mm-hmm.
calling cause number 2025 DCV 3947, Rosa Chavez versus Roger Carter et al. Announcements, please.
Good morning, Your Honor. Anna Zapalgoitia here for plaintiff.
Your Honor, Mark Chisholm for defendants.
Good morning. Are you all ready for a trial date?
Probably. We haven't. I've been trying to schedule depositions, Your Honor. We probably need a trial date next year. I've got $1 million in medical, and so I'm going to have a ton of it.
So Marissa, is June 4th, is that the date we're using today? I feel like I've said it a few times and I get worried that I'm putting too many.
June 4th has a couple spots still left, but May 21st is also available, Your Honor.
May 21st? Okay. Are you all, will May 21st work for you all next year?
2027?
Yes, sir.
Yes, Your Honor.
Yes, Your Honor.
All right, get your scheduling order together, include your agreed to mediator, return it to the court within the deadline, and you won't have to appear for the entry hearing. All your other dates will be set. If you need anything outside of those dates, make your request with the court, with Ms. Nieto, with your file pleading. Thank you very much.
Thank you, Your Honor.
Who's next?
Judge, staying on page 3, calling cause number 2025 DCV 4435, Martin Robert Belmonte versus Eduardo G. Hernandez et al. Announcements, please.
Good morning, Your Honor. Diane Gonzalez on behalf of the plaintiff.
Tony Aguilar on behalf of the defendants.
Again, scheduling status conference. Are you all ready for a trial? In 2027? I shouldn't say it like that. In 2027?
That's fine, Your Honor. We have mediation. I believe in the next couple of weeks.
On the 16th of April.
Yeah. Yes.
16th of April. Wow.
Yeah. Mr. Aguilar just came in on it and helped me move the case because they were pro se. So he jumped on it pretty quick with the mediation.
Do you want me to push this back 30 days and see how it goes at mediation, and then we'll look at setting a trial, or do you want your trial date now?
That'd be great, Your Honor. I think you okay with that, Mr. Aguilar?
I have no objection.
Okay, we'll reset this for 30 days. Good luck.
Thank you, Your Honor.
Have a good day.
Nice seeing you. Take care, Judge.
Nice to see you. Take care. Bye-bye. Who's next?
Judge, bottom of page 3, calling cause number 2025 DCV 4441, Roberto Sainz Diaz versus Just in Time Cargo Inc. Announcements, please.
Good morning, Your Honor. Jackie Crone here on behalf of the defendants.
Hector Longoria on behalf of the plaintiff, Mr. Sines.
Also, I have a notation here about an April trial setting. Is that what you all are asking for, or can I give you May 21st, 2027?
I'm okay with May, Your Honor.
I'm also okay with May, Your Honor.
That's going to be your date. Please get your scheduling order together, return it to the court, select your agreed to mediator, and include that in the order. All your dates will be there.
May 27th, is that right, Your Honor?
May 21st, 2027. Mm-hmm.
Thank you. Okay.
Okie doke. Thank
Awesome.
you so
Thank you, Your Honor.
much. Have a
Thank
good
you,
day.
Your Honor.
All right. Next.
Judge, on page 4, top of the page, calling cause number 2025 DCV 4542, Elizabeth Idali Terrazas Milan et al. Versus El Paso Independent School District et al. Announcements, please.
Katie Payne on behalf of El Paso ISD and Christine Miles.
David Morales on behalf of Ann Lucas
Rachel Lucas.
This is John Anderson, Your Honor, and I'm here for the plaintiffs.
And this is one where we're outstanding a scheduling order, and we were also missing our pro se, right? Our self-represented. I don't see him here.
I'm a little bit confused about that also, Your Honor. The attorneys for Ms. Lucas answered for him, my understanding, but when I spoke to them in a related case recently, that I think they said that may have been a mistake.
Yes, Your Honor. Your Honor, it was a mistake. We don't represent Mr. Gonzalez. I don't know
Well,
if I need to,
because at the last time he was here, you had offered to speak with him, right? You had asked him to give you a call.
well, we did, because I was concerned that without an attorney, he would slow down everything. And so, because he just claimed total ignorance of what was going on. But we sent him off. He said his brother was an attorney and the like, so.
But
No,
you
we
filed an
haven't.
answer on his behalf?
Yeah, no, Your Honor, it was about a mistake. I included his name in there, but I'll go ahead and amend the answer to just represent Ms. Lucas. I do remember now that his name was entered in there, but it was by mistake.
All right, we're here for entry of scheduling order. Do I have a scheduling order amongst the parties here absent Mr. Morales that is agreed to?
Gonzalez, yes, sir.
No, Judge, I don't think that we've come to an agreed scheduling order, but I'm sure that if you were to give us a trial date, we could put together one.
I thought I already did.
Yes, I asked.
You did, Your Honor.
Okay.
So the problem was we didn't have signatures, right? That's what I thought, and I thought the holdup was the self-represented. So do I have, absent Mr. Gonzalez, do I have an agreed to scheduling order?
No, Your Honor, my colleague has sent it around to all of the attorneys several times, and we have not been able to get agreement.
Why not?
Your
I'm
Honor,
not sure, Your Honor.
I know you don't. I know, Ms. Payne, not you, but from everyone else.
I thought we had agreed, Your Honor. I thought we had responded to her.
No.
But I hear if you need an agreement right now, we do agree with the scheduling
No,
order.
see, but that's why you then sign off on the scheduling order and return it to the court so that I don't have to come back and check with everybody and find out why there's no agreement. This is usually very standard. I thought the only holdup was Mr. Gonzalez. And so I had set this for a hearing in the event because he's appeared before, in the event that he appeared. But he is not here, right? We don't have him in the... So I don't understand why we don't have an agreement otherwise amongst you all attorneys.
Your Honor, I will pull out the email that Ms. Payne sent us, and we'll go ahead and sign off on that one and send it back to her. Is that all right, Ms. Payne?
Mr. Morales, I think you had agreed with all of the dates, but
Right.
we needed your feedback on an agreed mediator. And then I haven't gotten any feedback from the plaintiff's attorneys. And I know there are several in that firm, so I'm wondering if maybe Mr. Anderson himself was not on that email thread.
Okay. So we're going to reset this for 1 week. Okay? 1 week. If I have an order, you don't have to appear. But if I don't have an order, then I have to talk to you. Okay?
Yes, Judge, we'll get that taken care of.
Thank you very much.
Your Honor.
1 week.
Thank you, Judge.
All right. Who's next?
Judge, it would be on page 4, 2025 DCV 3420, Adora Chukwu versus Aryan M. Marivani, DBA, doing business as FCS Wrought Iron.
May I have announcements, please? Thank you, Ms. Nieto.
Good morning, Your Honor. Michael Hirsch on behalf of the plaintiff.
Hi, Mr. Hirsch. We're set for a status?
Yes, Judge. So if you recall, we were going to be filing a motion for default. And subsequent to that,
yeah,
an attorney reached out and sorry, Judge, go ahead.
No, it's I'm seeing, I believe we have Mr. Aryan M. Marivani is also present.
Yes, Your Honor.
Okay, thank you. Go ahead, Mr. Hirsch.
So, Judge, subsequent to us working on and getting ready to file the motion for default, an attorney representing Mr. Marivani reached out to the office after speaking with Mr. Lopez, asked essentially that we place this on a brief hold because they've reached a settlement that actually relates to another case that's ongoing with Mr. Maravani.
And so what are you asking from me?
So, Mr. Maravani, is that still the case?
Yes, as far as what Roa King, my attorney, had said, that there was a discussion of essentially dropping the civil suit due to full restitution being paid after work that had been completed.
So, Judge, we would just ask for, I guess, a 60-day entry of judgment. I think should be enough time for the conditions in the other case to be reached, which would settle this one as well.
Is that right, Mr. Maravani? A 60-day turnaround to close this case out?
Would the 60-day turnaround be for my client? I'm sorry, for Ms. Chuck Wu to receive the disbursement of funds?
I have no idea. This is what we're going to do. We're going to reset this for 60 days. You all can figure out whatever is happening in the background. And if I have some disposition, feel free to send it over before that 60 days, but I will check with you in 60 days. Okay?
Okay.
Thank you, Judge.
All right. Thank you for your time.
May we be excused?
You may. Have a good day.
Thank you.
Who's next?
Judge, on page 5, calling cause number 2025 DCV 2724, Elsa Dominguez Renteria versus Guillermo Navarro et al. Announcements, please.
Hector Longoria on behalf of Ms. Renteria, the plaintiff.
Good morning, Your Honor. Nicolas Campo, on behalf of Guillermo Navarro.
So it's all broken up, but I think it was Nicolas del Campo.
Yes, Your Honor.
Okay.
Good morning.
Good morning, Your Honor. William Miles on behalf of Manuel Nunez.
All right. Scheduling status conference. You want
Your
me?
Honor, I was going to say this case has been settled, Your Honor, so we're just going.
Best news I've heard all morning.
Okay.
So how many days, what timetable do you need?
Well, I just need my settlement checks and I'm ready to close it out. So I'm just waiting for that to come. So I don't have that power.
Your Honor, we need some lien information that we have not received at this time. We haven't requested the check due to that, but we have sent the release. We're just paying the lien information. That way we can request the checks and ensure that everything gets paid.
Okay.
I'll get them the info, Your Honor.
If I may interrupt, Mr. Longoria, I believe you're not settled with my client yet. Based on the information I have, do you know any differently?
Can I call you after this, Mr. Morales? Because I thought this thing had sort of, we've kind of buttoned this up because I got what I needed and that. So
I am operating on old information from 2 weeks ago when I told the court on the last hearing. So I may be wrong, Mr. Longoria, but I'd love to take that call.
Yeah, Your Honor, can we just reset this for 30 days and let me have a call with Mr. Morales and then try to square that up with him? And if there's some confusion, I apologize, Your Honor, and we'll come back to you and tell you something different if it is. But I think this one, my impression right now is this is going to shut down on your docket.
Reset for 30 days.
Thank you, Your Honor.
We're just going to reset the status conference for 30 days on the liens and stuff. We could have done longer, but we'll check in 30 days. All right.
Thank you, Your Honor.
Thank you, Your Honor.
Who's next?
Judge, page 5, calling cause number 2025 DCV 4908, Marcos Gonzalez Adioguén et al. Versus Nayeli Rodriguez. Announcements, please.
Tiffany Jody for the plaintiff.
Randy Grambling for the defendant, Your Honor.
Good morning. Do you all need a trial date?
We do, Your Honor.
Do you like May 21st, 2027?
If that's the soonest you have, we could take it.
The soonest? Maybe not. No.
I mean, I'm not saying that we need it like this year, but we could do it. I think we've already exchanged discovery. We're working on depots. I don't think it'll take too long.
Let me see. Ms. Nieto, are any of the civil dates like February, March open? Or are we truly in May?
I think there's one opening in April. Let me check on March. I think the first ones were already booked.
1 month's not going to make that big a difference.
I agree. Let's go with the May 21st.
I settled everything with Tiffany anyway.
May 21st.
That's why I need it sooner. Just kidding.
I can set you in December, but it really doesn't mean anything. There's
No.
no way. There's no way.
Missed
right.
that, Your Honor. Thank you.
Y'all get your scheduling order together, please, and just return it to the court with your agreed to mediator.
Thank you, Your Honor.
Thank you for
Will
your
do.
time. Who's
Bye-bye.
next? Bye-bye.
Judge, on page 6, calling cause number 2025 DCV 3070, Mia Adeline Cobos versus Ariana Adley Vasquez et al. Announcers, please.
Good morning, Judge. Anna Sabal-Goitia here again for plaintiff.
Good morning, Your Honor. William Wallace on behalf of Mr. Murphy for defendant Old American.
And good morning, Your Honor. Can you hear me?
Yes, I can.
Miriam Bird. Miriam Bird on behalf of Adriana for defendant.
All right. This is also a scheduling status conference trial date, and I think this might be the last May 21st, 2027 trial date I hand out, but that's what I'm offering. Are you all good with that?
Works for defense.
Agreed.
Yes. Agreed.
No objection to that date, Your Honor. However, we will be filing a motion to sever and abate on the issues. Yes.
Sounds good. Okay, so let's get our scheduling order returned with that date in mind, agreed to mediator. And if you need anything outside of those dates, let us know. The entry hearing is in 2 weeks. Please just make sure you return it before then, okay?
Thank you, Your Honor.
Okay, thank you
Are we
guys.
done?
Yes, have a good day.
Thank you. You as well.
Who's next?
Judge, going back to page 2, calling cause number 2025 DCV 1117, Laura Gabriela Embry Melton versus Robert Aguayo et al. Announcements, please.
Good morning, Your Honor. Manny Morga for plaintiff. Judge, I don't anticipate anyone here from defense, just simply the case settled.
Oh, okay. And what are we waiting on? Oh, God, it was set for a scheduling status.
Judge, I think there was just miscommunication as to who would file the remaining non-suit, but I'll make sure that gets done today.
That's all that's left, and that's why
Yes.
you're here.
Oh,
You're
yes.
here because all that's left is a non-suit.
Oh, I'd be too scared to miss a hearing, Judge.
Well, thank you for appearing. Get me your non-suit, please.
I will get it done today.
Thank you very much.
Thank you,
Okay.
Judge. Have a good day.
You too. Who's next?
Judge, on page 3, calling cause number 2025 DCV 2681, Miss Delphia Hoschel et al. Versus Mr. Cardona Rafael Angel et al. Announcements, please.
Charles Sanders, attorney for the plaintiffs.
This is set for a status dismissal. Let me pull it up. Okay, so it looks like it's been set for status dismissal. This is the 3rd time. What's going on this case?
We just are having problems finding the defendant. We thought he was in jail. He wasn't, Your Honor. Now my process servers are running traces to try to find him.
Yeah, so let's see. That's since January.
Correct.
Request for issuance. All right. So what are you gonna do?
We're gonna keep trying. I'm gonna hope you'll give me a couple more time. We're just gonna keep trying to serve him until you tell me I can't do it anymore.
Yeah. So this is gonna be reset for a status dismissal in 2 weeks.
All right. Thank you, Your Honor.
Mm-hmm.
All right, my excuse.
Next, you are.
Thank you.
Who's next?
Judge, on page 4, calling cause number 2025 DCV 2836, State Farm Mutual Automobile Insurance Company versus Daha Moose. Announcements, please.
Good morning, Your Honor. Leonard Ruiz on behalf of the plaintiff, State Farm.
All righty. Anyone here on behalf of defendants? Let me see. Where's the notice? We're set for default, Mr. Ruiz?
That's right, Your Honor.
And we're set at, okay, it's 10:20. Let me see. April 7th. What is April 7th? And here. Okay, that's just the filing of the service of the notice of today's hearing. Gotcha.
Yes, but please note that this, even though it's not required, well, by local rules they are, but we did send this notice to the defendants back on March 12th of this year, Your Honor.
Okay, and let me go back now to your motion. Your motion for default judgment was filed on January 13, 2026.
That's right.
For purposes of today's hearing, the court will take judicial notice of all the documents in the clerk's file. Mr. Rodriguez, you may proceed.
Absolutely, Your Honor. So our given the lack of an answer by both defendants, both the Hamuse and Canada Incorporated, we filed our motion. This motion includes everything statutorily needed, included a certificate of last known address and a non-military affidavit, Your Honor. The motion also includes a business records affidavit showing not only the liability, but also the amount of damages sought, Your Honor.
Okay, and the exhibits are, let's see, we got our certificate, military service. And what are you requesting? How much?
We're requesting liquidated damages of 22,468 with 18 cents, Your Honor. That corresponds 21,968 with 18 cents corresponds to the amount that it took to repair the subject property, and deductible of 500, which equals the 22,468 with 18 cents.
Okay. All right. All right, and the court will, I don't know if they're actually, I called them exhibits. I don't know, they're attachments to your default motion. The court has reviewed those, and the court is going to grant your request for default. Please submit your proposed order to the court. If you've sent it before, fine, please send it again so that I can, it'll come across my desk and I can sign off on it. Okay?
Understood, Your
Very
Honor.
much.
Absolutely.
Thank you very much for your time. Have a good day.
Very excused.
Yes, sir.
Thank you.
Oh, Mr. Bruno, everybody's starting to come in, but so let's see what else we can clean up before we get to that one.
Yes, ma'am, I have two ready for you.
Okay,
On page 6, Judge, calling cause number 2025 DCV 3182, Horizon Landvestments LLC versus Tom C. Batten et al. Announcements, please.
Good morning, Your Honor. Samuel Sprouse for the plaintiff, Horizon Land Investments.
Mr. Sprouse, we are set for a status conference and my system is slowly loading. So do you want to just tell me a status really quickly?
Yes, Your Honor. All defendants have been served by internet publication. That was back on February 20. So citations were on file for 28 days. 42 days have passed and no one has filed an answer as far as I know. So we have a pending motion to appoint an attorney ad litem.
I just seen that was filed on April 1st. Is there, let me see.
And I did, at the last minute, email a proposed order to the court coordinator. She probably hasn't had a chance to see it yet.
Okay, I was just looking, sometimes there are requests within the motion on someone in particular. The court will grant your request, obviously, and appoint the ad litem. And so I'll look for that order. We're going to set this for another status in about 30 days.
Okay.
And that might be pushing it a little bit. Do you have a preference?
Well, do you think that the ad litem will be appointed without a hearing in between that time period?
Yes.
Okay. then maybe 60 days, and we can see what the progress is for the ad litem.
Okay, 60-day status. And I'll look for the order, Mr. Sprouse. Okay,
Thank you, Your Honor.
thank you very much. Let's
Okay,
get to the
Mr.
next one. Yeah, 2025 DCV 3191 Horizon Land Investments LLC versus Rodney V. Bertrand et al. May I have announcements, please?
Samuel Sprouse for Horizon Land Investments.
Status as well, Mr. Sprouse? Is this?
The status for this case is identical to the last case.
Okay.
I think even the dates line up the same. So there's an order that I emailed this morning to the court coordinator that's pending.
Okay. So that's an ad litem as well, 60-day reset.
Yeah, please, thank you.
Thank you very much. Have a good day.
You too.
Who's next, Mr. Nunez?
Judge, top of page 7, calling cause number 2024 DCV 3622, Cesar Sanchez et al. Versus Blanca Hotcasitas et al. Announcements, please. Mr. Gonzalez?
Mr. Gonzalez and Mr.
Yes.
Who is the?
Hi, Judge. Good morning.
Good morning.
The
Plaintiff's counsel.
yeah, Your Honor, plaintiff's counsel is oh my God, Ansel Escobar. But Judge, this case has been continued. The court did send us a discovery control plan and scheduling order at our last hearing. I showed up today because I figured the status hearing was still the status hearing. But it is currently set for trial and we're working on a scheduling order.
Why can't what is that echo? That is so weird. Give me a second. Oh, it looks like the hearing was canceled?
Oh, well, I didn't know about it, so I figured I better sign in.
Well, hold on a second. It's on the docket.
Oh, okay.
It's on the docket. I'm not sure why. Marissa, do you know why we on April 1st set this for hearing today? Let me go into my emails.
Judge Marissa's on the phone.
Okay.
Maybe Ms. Dulan can help us out?
Yeah, I don't know. But Mr. Gonzalez, I'm not gonna make you wait any longer.
Okay.
You showed up and it is on our paper docket, but it is canceled on Odyssey. And just in looking at my emails, the last thing I have is a request for continuance. Let me see.
Correct. Yeah, Judge, and you granted that. The court has also sent us a discovery control plan and scheduling order for us to work on dates and stuff.
Yeah, I'm just not sure why there was an order setting this hearing on April 1st. So you have your trial track. The entry, did you all return the scheduling order?
Not yet, Judge. I'm still
Okay, I
trying
was
to
gonna
figure
try
that.
and save you a date because April 22nd is the entry of the scheduling order, but no. Está bien. Thank you.
Okay, thank you, Judge. Have a good day.
Good day.
Okay, bye-bye.
Also, 3619 has been taken care of, Mr. Nunez. The New Deal Mercantile case.
Thank you, Judge. That just leaves at 10:30. Did you want to wait a minute?
Yes, because I want to go backwards and make sure. Are you sure that what is Mr. Francois here for? 0886.
Yes, ma'am.
And then on page 50040. I see Mr. Lopez. These are all my Cabral people coming in. Mr. Lopez, are you
Yes.
on Jasmine Silva?
So Judge, we got that one case got settled. We have an ad litem appointed, and I think today's hearing got canceled.
Oh,
okay. I'm just on to watch another hearing.
Okay.
But yeah, the court's already set us for an entry of judgment and
Okay,
and,
so
Silva.
0040 is taken care of. Okay.
Yes, Your Honor.
Thank you. And then the friendly suit. Ooh, we got a lot. So I don't see anybody else except our Cabral folks. Are all my Cabral folks here? But hold on a second. Sorry, Mr. Francois, I didn't mean that. I take it back. Is his case on the docket still? Oh, you're on Cabral. I'm sorry.
Yes, Your Honor.
You're a new face to me. You're not part of the old gang.
Yes,
The
Your Honor.
old gang.
I'm appearing on behalf of Brian Cathy. He's stuck in another trial and it carried over into today, so I'm covering this for him.
Give him my regards. All
Will do.
right.
He's sorry he couldn't be here. He was very excited to appear.
So are we ready? Is this everyone? I'm not used to so few.
Your Honor, I believe everyone's here for the plaintiffs. I believe I will be taking the lead for the argument, Nick Bruno, and I see Kevin Lyles here as well.
Yes. Okay. All right. Well, then let's get started. Calling cause number 2022 DCV 0886 Eduardo Cabral et al. Versus RV Share LLC and Landstar Ranger Inc. May I have announcements, please?
Yes, this is Nick Bruno on behalf of the plaintiffs.
Kevin Lyles, too, on behalf of plaintiffs, Your Honor.
Good morning, Your Honor. Landon Francois on behalf of defendant.
And I'm here as well, Your Honor. Carlos Rincon. Good morning to you and to everybody.
Good morning, everyone. We are set this morning on defendant's motion to modify, correct, or reform judgment. Mr. Francois, are you handling it?
Yes, Your Honor.
Go ahead.
Thank you, Your Honor. First, I'd like to note that the motion that we filed was actually overruled by operation of law on March 30th, 75 days from the date of final judgment. However, Your Honor, you still have the authority to modify the judgment up until plenary power expires on April 28th. So we would request any ruling on this motion before April 28th. And as you know, we filed a very detailed, lengthy motion to modify that tackles many issues. I'm cognizant of the fact that you have a very busy docket today, so I'd like to just kind of focus on two issues at the hearing. The first is that Landstar cannot be jointly and severally liable because it is not vicariously liable for the driver's negligence. And the second is that there was no evidence of negligent retention of an independent contractor, and the court should render a take-nothing judgment in favor of Landstar. On the first issue, plaintiffs put on two theories of statutory employment and vicarious liability under the Federal Motor Carrier Safety Act. The first is derived from statutory employment as a motor carrier, and the second is based on the definition of employee as found in Section 390.5 of the Federal Motor Carrier Safety Act. But Your Honor, the jury in its final jury charge and answer to question number 1 determined that Landstar at the time was acting as a broker and not a motor carrier on this particular load. What that means is that it forecloses the plaintiff's ability to impose vicarious liability on Landstar for the negligence of the driver's sin. And what that does is it completely eviscerates any joint several liability. It would at most allow them to recover only the 15% that the jury apportioned to Landstar in its apportionment findings for the other negligence. And I just very briefly, Your Honor, if I could, is it possible for me to share my screen?
Yes, sir.
I'd just like to direct the court to a couple of filings that were relevant in this case. So first, I'd like to turn to plaintiff's live petition at the time that trial happened. This is their 7th amended petition. You can see here that they pleaded that Landstar is liable as a statutory employer. This was their only path to vicarious liability against Landstar. First, they talk about the statutory employee doctrine under 390.5 and right responsibility regulations. They set out these 4 elements right here. And the very first element of statutory employment is that the entity is a motor carrier and not a broker. So question number 1 of the jury charge resolves this issue. The jury found that Landstar was a broker, not a motor carrier. So they could not be acting as the statutory employer at this time. The court has already denied the plaintiff's motion for J&OV on question number 1. So for a judgment to be entered in accordance with the jury's verdict, there cannot be statutory employment or vicarious liability for the driver. And this is plaintiff's own pleading. The second theory that they allege is this employee definition in section 390.5, which says that employee can include a driver of a commercial vehicle, including an independent contractor, while in the course of operating a commercial motor vehicle. The problem is that that definition, the Texas Supreme Court has already reviewed and determined that it does not expand liability beyond people directly employed by the motor carrier, or in this case, by Landstar. In a case, J&M Express v. Lozano, 2024 out of the Texas Supreme Court, the site is 688 Southwest 3rd, 327, and the pin site for this particular provision is 333 to 334. The Texas Supreme Court specifically analyzed 49 CFR 390.5, which is this employee definition, and it says, but the employee must still be, quote, employed by the employer, either directly or as an independent contractor. And it goes through evidence in that case, which indicated the driver was not directly employed by the motor carrier. So too here. And that's because, again, if we look at plaintiff's own filings, plaintiff moved for directed verdict on this very issue, specifically saying that Landstar did not employ the driver. And that's because if Landstar employed the driver, they couldn't hit Landstar with statutory employment status. So they can't have it both ways. They can't say that Landstar never employed this driver, didn't directly hire this driver, didn't directly retain Singh as an independent contractor, but then still try to hold us vicariously liable under section 390.5 of the regulations. The Texas Supreme Court has said that that's not permissible. So under either theory, the statutory employment, that fails because element one, the motor carrier status, that goes against the jury's verdict. The jury has decided that against plaintiffs. The court has declined the JNOV. And then their option two, this definition in 390.5, that's foreclosed by their own admission, their own moving for directed verdict on the fact that Landstar did not directly employ the driver. They did not directly employ Singh. They retained My Universe as a motor carrier. My Universe is the one that employed Singh. There needs to be a direct relationship between Landstar and Singh for that 390.5 definition to work. It doesn't account for subcontractors like that or employees of an independent contractor. And so for those reasons, Your Honor, Landstar cannot be jointly and severally liable for the entirety of this judgment. Landstar was only assessed 15% liability. Their entire theory is based on attacking on that additional 50% that was assigned to Singh. And then, Your Honor, I'd like to move on to talking about the fact that there's no evidence for that to support that 15%. But if you have any questions about this provision, please let me know now. And otherwise, okay. And so moving on to the second big point that I'd like to address is that the plaintiffs put on no evidence at trial to support this negligence finding in the question number 4 of the jury's charge. And I'll scroll down to that. Which is that negligent selection of an independent contractor. The only basis for this is that My Universe did not have a safety rating from the DOT. However, the fact that the DOT didn't assign them a safety rating has no bearing on whether or not they were an authorized motor carrier, because they had a DOT number. They were authorized to transport loads. There was no evidence that they had some sort of well-known history of danger. That the evidence at trial just is completely insufficient to support this negligent selection of an independent contractor, which is a very high bar usually, because by nature, independent contractors are supposed to work independently. So there needs to be some sort of knowledge available to Landstar at the time of selection that directly relates to what ultimately causes this collision. Landstar didn't know Singh personally. They had no duty or obligation to review any driver that may potentially drive the load that they act as a broker on. That's not part of their obligations under the Federal Motor Carrier Safety Act. And it certainly effectively eviscerates the entire point of the motor carrier provisions and the authorization of motor carriers. The DOT has already said that My Universe is a valid motor carrier that can act in this way. And to say that we were negligent in selecting them because they didn't have an additional step of a safety rating isn't supported by any of the statutes, the regulations, or any common law duty on the part of Landstar. And so, Your Honor, we raised many other issues in our briefing, but just the last point on that I just like to highlight is the jury apportioned the 15% to Landstar. So even if the court doesn't want to enter a JNOV on question number 4 as to that, it should, just based on the jury's answers, at most cut this to a 15% liability for Landstar and reform the judgment to reflect that Landstar is only responsible for 15% of the total damages. And that question number 1, that broker answer, that renders question number 2 and question number 3 completely irrelevant, because those are just other elements that you first need the motor carrier finding to get to. It'd be like if you separated a negligence question into duty, breach, and proximate cause. If the jury answered no to breach, but answered yes to proximate cause, it wouldn't make a difference because you still haven't hit all of your elements. And as I said earlier, by plaintiff's own admission, in their motion for directed verdict, in their petition, they admit that these are the elements and they didn't satisfy them. And so for that reason, Your Honor, we request that the judgment be reformed. We request that Landstar, that the court enter a take nothing judgment, but alternatively, we request that at most the court assign 15% liability to Landstar.
Thank you. Thank you, Mr. Francois. Mr. Bruno?
Thank you, Your Honor. I will be brief, and I invite the court to interrupt me at any time with questions because you've heard a lot of this argument before. You've heard this argument at the summary judgment stage. We had a lengthy discussion on these points at the directed verdict stage, at the couple days of charge conference that Your Honor held, as well as 2 hearings on the motion to enter judgment where you heard these identical arguments. This is not a case where I can say that the arguments have not gotten better with time. In fact, they've gotten worse with time. I'll get to that in a moment. I'll just touch on the 3 points that that Landstar raised. Let's start with the Section 390 issue. As the court will recall, we had an extensive discussion about how to submit the 2 separate motor carrier questions to the jury. If you recall, there was lengthy discussion about the Morales decision out of the Southern District of Texas, which outlined 2 distinct paths to motor carrier status. One was under the control regs, and that's the theory that requires those 4 elements that are listed in the petition. There is a separate and independent theory of motor carrier status under the 390 definition. The 390 definition, the questions 1 and 2 submitted the elements for the control reg theory, which we believe we established as a matter of law. But this court made a disciplined ruling to only to not grant our JNOV on that ground, and to only grant the issue of judgment based upon the theories that the jury found in our favor. Question 3 was an independent basis to motor carrier status. That's separate and apart from question 1. There's a separate definition in Section 390. That definition is what the jury found in our favor. Question 3 is an independent basis for motor carrier status. I want to talk about the Lozano case that Landstar just referenced. I find it interesting they referenced that decision because the Supreme Court did quote the Section 390 definition, and immediately after quoting the Section 390 definition, there's a quote from the opinion which the Landstar did not read you. Quote, "This definition eliminates the common law employee independent contractor distinction in order to discourage motor carriers from using the independent contractor relationship to avoid liability exposure at the expense of the public," end quote. What the court goes on to say is in that case, the only evidence supporting an employment relationship of any kind was a crash report from the incident. And they said that crash report standing alone does not explain the basis of why the entity in that case was listed as an employer, and that was insufficient as a matter of law to establish motor carrier status. That's not this case. We are not relying on one specific document. And then the court goes on to say, nowhere in the record does the record show that the entity, quote, assigned Mr. Lozano to the particular drive at issue, or for that matter, to any drive, end quote. That's not this case. This case is the court will recall, it involved extensive evidence that Mr. Singh was driving on behalf of Landstar for this particular load. It's just a different record in Lozano. Lozano blesses the approach that the jury found, that 390 is an independent basis. It's just very factually distinguishable. So that's 390. That's one independent way to the judgment the court rendered. There's no reason to disrupt the several rulings the court has already made throughout the course of this litigation. I'll turn to the negligent selection, because that theory, as the court will recall, is, again, independent. Even if Landstar is not a motor carrier, they still are liable for negligently selecting My Universe. And I find some of the wording that Landstar used in this argument just now important to parse. They stated that My Universe was an authorized motor carrier, so that therefore must have established that they were competent to be selected. That's not what the evidence showed. The court will recall we had a lot of discussion about the poor safety record of My Universe. There was expert testimony that any reasonable selector of an independent contractor would not have selected My Universe. There's a distinction between being authorized, so similar to somebody merely having a driver's license, versus then it being a good idea to allow that person to operate the equipment. In this case, there was plenty of evidence in the record to support the jury's finding. Court heard all that. It denied directed verdict on this very basis when that evidence was fresh in everyone's mind. Again, this issue has been litigated repeatedly. There is plenty of evidence in the record to support that finding. The third theory you didn't hear anything about was the non-delegable duty theory, which the Supreme Court has blessed, that a motor carrier such as Landstar owns a non-delegable duty to ensure compliance with the federal motor carrier safety regulations. Again, we discussed this theory at length at the charge conference, directed verdict, post-judgment, or post-trial. That's question 5 is another basis for liability. So there is nothing new presented to the court to say that Landstar is liable for nothing. So that leaves the passing reference at the end to the joint and several liability. This is where I will end where I began, that the argument has gotten worse over time, not the same. If you recall, we've had extensive discussions on this issue. I will point the court in particular to our January 6th filing, which is a response to Landstar's objections to our proposed judgment, where we brief for each one of the independent theories that I discussed, the case law demonstrating that Landstar's negligence has to be combined with My Universe's or Singh's negligence based on, and we gave case law for each one of those independent theories. As the court will recall, the case law is clear that when a defendant is vicariously liable, like with a negligent selection claim, like with these motor carrier claims, the case law says, and I'll quote from the Kunkel v. Cherry decision, which the court will recall from our previous arguments, that the driver's responsibility, quote, is imputed to the owner/employer. When I say the argument's gotten worse over time, if you recall, Landstar originally claimed that they had 2 cases that supported its view that the driver's negligence was not imputed to the motor carrier or the negligent selector. This North American Van Lines v. Emens case out of Beaumont and Dow v. Garcia out of Dallas. But we pointed out in our response to briefing, those cases actually said exactly what the plaintiff's position was. The North American Van Lines case said Karchnega, the driver in that case, was in the course and scope of employment for Lufkin Moving. Lufkin Moving is therefore vicariously liable for his 5% negligence in addition to its own direct liability, end quote. Again, it supports the idea you combine both the driver and the employer. The Dow v. Garcia case said the same thing. Quote, there is sufficient evidence supporting the jury's finding that the appellant negligently entrusted her car to driver Parks. Because the jury allocated 85% causation to Parks, the 85% of responsibility that the jury assessed to Parks was passed on to the appellant, end quote. What's interesting is when you just heard the argument in this proceeding, there was no case law cited as support for the idea that you do not impute the driver's liability for purposes of Chapter 33 in reducing the judgment. That's consistent with their post-judgment briefing. You look at pages 55 to 57, where the defendants make this argument, there is absolutely no case law reference. In other words, originally, when the defendants made the argument that Landstar is only 15% responsible, at least they gave the fig leaf of 2 cases they purported supported that position. Upon closer review, it's clear those cases support the exact opposite proposition, that the negligence of the driver is imputed to Landstar, thus Landstar is over 50% responsible and jointly and severally liable for the entire judgment. When that was pointed out, they could find no contrary authority. In fact, they removed the references to the only authority they previously found. The court had heard this argument several times, both in 2 post-trial hearings, as well as several rounds of post-judgment briefing. This is nothing new. In fact, the defendant's argument has gotten worse in this regard. So there's nothing new for the court to determine, as defendants noted, that their post-judgment motions were denied by operation of law. The court should stand by its original rulings.
Thank you, Mr. Bruno. All right, Mr. Francois, you have a brief response? If you do, I need you to unmute.
Apologies, Your Honor. I'd like to briefly respond to 2 kind of arguments that were just made there. So plaintiffs are focusing entirely on 390.5, disregarding the motor carrier finding in question 1. So again, if we turn to the Lozano case, which plaintiffs say that we didn't quote all of it, the factual circumstances are different, there was no actual evidence of direct employment, but Lozano is very clear that the employee must still be, quote, employed by the employer, either directly or as an independent contractor. Here's the driver, Mr. Singh. And again, if we turn to plaintiff's own motion for directed verdict, they moved for directed verdict saying that it was conclusive evidence that Singh was not directly employed or retained by Landstar. So now they want it both ways. They want you to not look at Lozano, which involves admittedly a different factual circumstance, but they themselves have argued in this case that there is no evidence to support a direct relationship between Singh and Landstar. That's dispositive on the issue. They can't have it both ways. And then on the second thing that I'd like to bring up is he referenced the motor carrier non-delegable duty as an independent basis for assessing Singh's liability and imputing it to Landstar. That comes from Section 390.11 of the Federal Motor Carrier Safety Act, which is a duty prescribed for a driver is imposed upon the driver, and the motor carrier has to observe such duty or prohibition. Again, that it's precluded by the fact that the jury determined that Landstar is not acting as a motor carrier here. So they cannot impose this non-delegable duty theory of liability on Landstar when the jury clearly and conclusively found that Landstar was not acting as the motor carrier. That's the only basis for the non-delegable duty responsibility. There is nothing in the Federal Motor Carrier Safety Act that imposes non-delegable duties, imputes them from driver to broker. It only goes between motor carrier and driver. And we know Landstar was not a motor carrier. You don't have to alter the jury's verdict at all to reach that conclusion. So under even their arguments today, there is no basis to impute Singh's liability onto Landstar. Again, the direct negligence claimed against Landstar for its negligent selection, kind of like a direct negligence hiring or retention claims against employers, that's still 15%. That's what they should be limited to if the court declines to set aside that jury verdict for the reasons that we've briefed.
Mr. Bruno, I don't know if you have a response. Frankly, I think I'm good. I know I have an answer that you all filed. It's a very short answer.
Correct, Your Honor. I'm happy to answer any questions the court has, but we've briefed this issue extensively. I think the court knows our position.
Yeah, no, I don't have any questions. I do want to review fully that 3-4 page answer that was filed a few days ago, and I'll have a response for you very shortly.
Thank you,
Your Honor. May I request a copy of the transcript from this record? I don't know who I would ask directly.
Mr. Chiriboga is there. I don't know if he requires an email, maybe.
Okay, I'll get Ms. Roberta to do it.
Yeah.
Okay.
Okie doke.
Thank you, Your Honor.
Mr. Rinconia, just request an email.
Yes, sir.
The transcript you're looking for. That way we have a record of it.
Yes, and your Jets your Jets helmet cup is duly noted on the record.
That's why it's there.
Don't get him started, Mr. Rincon. We went through a whole thing on the baseball and yesterday and during our criminal docket.
Yeah. Okay.
Walter's on fire right now.
Yeah.
Well, thank you all. I truly do appreciate your time and your arguments today, but I don't want to keep you any longer. If you don't have anything else, you all are excused.
All right, Your Honor.
Thank you,
Take
Your
care.
Honor.
Bye-bye.
Thank you, Your Honor.
You all take care. All right, we have 11 a.m. friendly suit, right?
Yes, ma'am. I think on page 8, I think that 3659 is here.
Oh yeah.
Yes,
Well, that's
ma'am.
another one. 3695.
Yes, ma'am. You want me to bring them in?
So let's yeah, we can take care of that, but we probably need a minute. You need a minute, Walter? See, we're gonna take a quick minute and then they're set at the same time. So yeah, let's take care of Mr. Rasmussen's case first, and then we can get to the friendly suit. Who all is here? I haven't looked at the waiting room.
I think Mr. Rawls and Mr. Rasmussen are both here for that.
Okay, I'm bringing them in.
Yes,
I
ma'am.
gotta think that cast iPhone has something to do. That's the friendly suit. They're not here yet. So if you'll just let them know as we get started on this hearing, because I think this is one definitely that has been reset a couple of times, that we will be with them shortly because
Yes,
they
ma'am.
have some individuals. Who's the ad litem on that friendly suit? Hmm. Mr. Rasmussen, Mr. Rawls, are you there?
Good morning, Your Honor. Damian Rasmussen here.
Good morning. We'll
Good
be
morning, Your Honor. Jordan Rose for the defendant.
We'll be right with you. We have kind of we had several contested hearings today, and you all are one of them, and I know you've been reset. So, but we have you set at the same time as the friendly suit. I just needed to give our court reporter just a quick break, okay? And then we'll be right with you.
Understood.
Thank you.
Hello, Miss Lewis. I'm gonna put you in the waiting room. Please don't leave, okay? Thank you. Well, ma'am, are you here for the friendly suit?
Yes, I am.
Okay. Be just a minute, okay? I'm gonna put you in the waiting room and I'll bring you in right now.
Okay, thank you.
All righty, Mr. Rasmussen, Mr. Rawls.
Good morning.
All right, good morning. Are you all ready?
Yes, Your Honor.
Okay. All right, Walter, you ready? Calling cause number 2024 DCV 3695, Janet Salazar et al. Versus PPSL Legacy at Cimarron. May I have announcements, please?
Good morning, Damian Rasmussen on behalf of the plaintiff.
Good morning, Jordan Rawls, on behalf of the defendant.
Good morning, and I'm gonna pull up the entries because I feel like this hearing has been reset a few times, and so thank you for your patience. We're in a little bit of, I hate to call it a lull because we're so busy, but we're in between trials right now. We're about to be in another one, so I'm glad you're here and we can hear this finally. So I have a motion to compel arbitration. Is that right?
Yes, Your Honor.
Okay, and let me make sure because I'm seeing a lot of things filed. And I feel like we had several things filed that I think some had gotten resolved, and I just want to make sure we don't have anything outstanding. Is the motion to compel arbitration? Let me see, hold on. I should have looked at my docket notes. The motion to determine plaintiff's claims are healthcare liability claims. That's the other matter.
So, Judge, it's my understanding, sorry, I didn't mean to interrupt you, but we have the motion to compel arbitration, and then we also have a motion to compel discovery.
Gotcha. And the additional motion that I mentioned, that one is also set today, no?
No, I think that your staff said that we had only allotted time for these two motions on an email that was last week, and that would be set at a later time. But Judge, your staff is well more educated and versed in that than me. I don't want to speak for them, but I think that's what happened last week. That was just filed.
Well, let's start, and I have a notation here that the additional motion was on file. I want to start with the arbitration, the motion to compel arbitration. So is that you, Mr. Rawls?
Yes, Your Honor. And may it please the court, this is a straightforward arbitration enforcement case. There is a written residency agreement that governs Mrs. Powell's admission and care at the defendant's facility. That agreement contains a binding arbitration provision, and plaintiff's claims arise directly from the services provided under that agreement. And so under both the FAA and the Texas law, arbitration should be compelled. Here today, the court's role is very limited. First, it must decide, is there an arbitration agreement? And second, do the claims fall within that scope? If both are satisfied, then the court must compel arbitration. Doubts should be resolved in favor of arbitration. And here, Your Honor, both elements are met. There's a written arbitration agreement executed on admission. It applies to any of the disputes related to the performance of those services. Plaintiff's claims here are directly based on the care provided at the facility, so these would fall directly within that scope. The agreement was executed by Mrs. Powell's spouse in a representative capacity on admission, and the facility relied on that representation throughout her residency. There is no evidence before the court that he lacked authority. There's no testimony and no evidence of forgery or lack of consent. But even if the court were to have concerns about authority, enforcement is independently supported by the direct benefits estoppel doctrine. Mrs. Powell resided at the facility. She accepted housing. She accepted care services under that residency agreement. And plaintiff's claims directly arrived from alleged failures to provide those services. This doctrine alone supports enforcement here. Plaintiff also argues in their response that these are independent claims. They are not. Under Texas Supreme Court precedent, wrongful death claims are entirely derivative of the decedent's rights. So here, if Ms. Powell had been bound to arbitrate, her statutory beneficiaries should be bound as well. And under both Weekly and Labatt, plaintiff should stand in the shoes of Mrs. Powell. And here, plaintiff also argues that the Texas Arbitration Act personal injury exclusion applies here. This does not apply. The FAA governs this agreement and preempts state limitations. And also in their response, they argue unconscionability. There's no evidence of unconscionability before the court today. There's no affidavit, no factual record. There's only argument that this is unconscionable, and that is insufficient to defeat arbitration. And so, Your Honor, the defendants seek enforcement of under three independent grounds: that one, a valid arbitration agreement governing the resident exists; direct benefits estoppel doctrine applies; and the derivative nature of wrongful death claims under Texas binds the plaintiff's claims to arbitration. And for each of these reasons, the arbitration should be compelled, Your Honor.
Mr. Rasmussen?
Thank you, Judge. Your Honor, the defendant seeks the dismissal or abatement of this lawsuit based on the arbitration clause contained in the 2018 residency agreement. And Judge, the defense does accurately say that under federal law, arbitration is favored. But, Your Honor, arbitration remains a matter of contract and consent. The party seeking arbitration bears the burden to prove, one, that there was a valid arbitration agreement that existed; two, that the agreement binds the party opposing the arbitration; and three, the claims fall within the scope of the agreement. And Your Honor, the defendant has not met that arbitration. There are several issues I'd like to point out. One, there's no proof of authority. The arbitration agreement fails at threshold because Ms. Powell never signed it. There's no evidence that she ever agreed to arbitrate. The defendant's motion states that Jack Powell signed as guardian. And Your Honor, that's significant because there's no guardianship order or other proof of legal authority in the record. Calling someone a guardian does not mean they're one. There's no court order, there's no authority, and there's no agreement by Ms. Powell. As Your Honor knows, in Texas, a spouse or family member does not automatically have authority to waive another person's litigation rights. The agreement itself does not clearly identify Jack Powell as a court-appointed guardian, and the defendant has provided no documentation establishing that authority. They've just glossed over it completely. Therefore, he had no legal authority to bind Ms. Powell to arbitration. And Your Honor, if he lacked authority, the agreement is invalid. And since it's invalid, anyone claiming it is also invalid. Without such proof of authority, the defendant has not shown that Betty Powell was bound by the arbitration clause. Issue number two, Your Honor, the plaintiff, Ms. Salazar, never agreed to arbitration. She never signed the residency agreement. And Your Honor, wrongful death beneficiaries, in this case, the wrongful death beneficiaries never signed an agreement and cannot be compelled to arbitrate. Wrongful death beneficiaries are not bound by agreements they did not sign. Ms. Salazar is the one that brings this claim, and she brings the claim individually under the Texas Wrongful Death Act and as representative of the estate. As Your Honor knows, wrongful death claims belong to statutory beneficiaries and rise independently under Texas law. It's an independent claim. The defendant has not shown that the plaintiff agreed to arbitrate those claims and can't be compelled to do so. Issue three, Your Honor, the scope of the arbitration clause. Again, I believe this was glossed over by the defendant. But even if you were to find, which we don't contend that a valid arbitration agreement existed, the defendant must still show that this lawsuit falls within the clause, that the arbitration clause applies to disputes. And it says in there, with respect to the terms or provisions of the agreement or with respect to the performance of the parties. Now, Judge, this is a case that involves Betty Powell, who was it involves supervision and monitoring of Miss Powell from 2024 when she was found trapped underneath a mattress box spring in another resident's apartment and died the following day. It has nothing to do with the agreement, the residence agreement. It's completely outside the scope of the arbitration clause. We're not asking the court to interpret or enforce the residency agreement. This is a negligence and wrongful death case involving the supervision of a resident in this facility. The defendant has not shown that these tort claims fall within the scope of the clause. And Your Honor, just for reference, the Texas arbitration agreement explicitly says in there that personal injury claims are excluded. Number 4, Judge, the FAA does not change this analysis. The defendant argues that the Federal Arbitration Act governs. And Judge, even if the FAA did apply, the threshold question remains is whether a valid arbitration agreement binds the parties together. Again, it has to it's our position that the FAA enforces arbitration agreements, but it does not create them. And because the defendant has not proven consent, authority, or scope, the FAA does not require arbitration here. Judge, the next issue is you have to take into account the litigation conduct. The defendant has already answered the lawsuit. They've already participated in discovery. They've produced witnesses to the depositions. I believe we've taken 7 depositions. They've sent us discovery to answer interrogatories and requests for productions. Contractual arbitration here, rights can be waived through litigation conduct inconsistent with arbitration. Your Honor, we have a trial setting in June, and quite frankly, Judge, it was set in May, and we were ready for that. But defense counsel, his partner, his son was graduating, so I agreed that he should not have to miss his son's graduation for trial. But we're on the doorstep of trial. We're ready to go, and my client wants her day in court with a jury. So, Judge, at a minimum, the conduct raises a question whether the right to compel arbitration has been waived based on how much of this we've done. Judge, this case also involves unresolved discovery issues, and we're going to get to that in the motion to compel. But just in closing, Your Honor, arbitration is not a matter of consent. The defendant has not proven that the person who signed the arbitration agreement had legal authority, that the plaintiff in this case agreed to arbitrate, and that these claims fall within the clause. For these reasons, Your Honor, we'd ask that the court deny the motion to dismiss to compel arbitration, and that we proceed with our jury trial in June. Thank you, Your Honor.
Mr. Rawls, your response?
Yes, Your Honor. The defense would argue that non-signatories are bound and can be compelled to arbitrate their claims under the direct benefits estoppel. So it's not necessarily that Mrs. Powell did not sign it. She is bound by it because of the estoppel, the direct benefits estoppel. She accepted admission. She accepted care. She resided in the facility during those times, and now they seek to, get out of the arbitration agreement, which they agreed to upon admission. As far as the invoking or the amount of litigation that has been done, this motion to compel was filed a while ago, and it has been reset several times. The parties did attempt to do early mediation in hopes that they could resolve it before the arbitration agreement was resolved. That mediation proved unsuccessful, and therefore we are pushed forward with this motion to compel arbitration based on the valid arbitration agreement that was executed upon admission, and that plaintiff's claims, which involve supervision of the resident in an assisted living facility, are healthcare claims and involve the care and services that are under the arbitration and admission agreement.
Okay. Alrighty. So I'm going to review a few things on the motion to compel arbitration. Because you're here, I'm happy to hear any argument on your motion to compel production. But frankly, I know we have responses. These are kind of been, I got to think, have they narrowed down or are they all still outstanding? Have you all heard?
Judge, the problem is, as we've continued with depositions, witnesses who work for the facility of the defendant have said that documents do exist when counsel has said they do not. So I just need something on the record because we do have a spoliation claim, and but I'm happy to work with the defendant to get these documents. We just did a waive of deposition several weeks ago. They specifically said EMAR documentation and audit trails exist, where they specifically said that a bunch of these policies, work history, time charts, all this stuff does exist when they previously said that they don't. However you want me to handle it, Judge, I can work it out with them and try to. It's not a situation where I would tell you, Judge, I can't get along with the other side. That's not the case. We can try to do that, but I do believe a lot of these documents exist that we haven't been provided.
So if you all have not conferred, or circumstances have changed because of ongoing discovery, I'm going to encourage you all to do that, although I know we have our arbitration ruling outstanding. So for my purposes on the motion to compel the discovery, that I am going to reset for that April, well, golly, it's only a week away. April 15th final civil pretrial. It's a short timetable. Can you all confer and then we'll just come back next week on the motion to compel on the discovery?
Yes, Your Honor.
Yes, Your Honor.
Okay, so that will be reset for the 15th. At the same time that we have our final civil pretrial. To the extent you can update the court, I know we did one of these earlier today. It's extremely helpful if you all can prepare ahead of time, ahead of the hearing, any either proposed order or a list or an email, something that tells me what's resolved and what's outstanding. One of the things that came up this morning was, per request, there were certain objections that were maintained or being withdrawn, and it was just a hodgepodge of things. It's much more helpful if I just know exactly what I'm dealing with whatever is outstanding, okay? And that can help me go through it quicker. But with that, I do need to, I'm not sure I heard from you, Mr. Rawls, on the motion to compel arbitration. A response, and maybe I may have missed it, I don't know, on the argument regarding the nature of this type of claim and the claimant being outside the scope of the arbitration agreement?
Yes, Your Honor. The arbitration agreement is, it says that it applies to all claims that with respect to any of the terms or provisions of the admission agreement. The defense would argue that as a healthcare provider, a assisted living facility, they were providing care and services that constitute healthcare, and they provide those to Mrs. Powell. And plaintiff is making allegations that there were failures in providing of these services, such as monitoring, supervision. The defense would argue that there's no way to slice those from healthcare, and that the services provided are healthcare and they were outlined in the admission agreement.
Okay. All right. So, Mr. Rasmussen, tell me, how do they fall outside of the arbitration agreement? And you're muted.
You're muted, Damien.
Sorry, Judge. Again, That's assuming that we do have a valid agreement, which it's our position that we don't. But as far as the scope of the arbitration clause, Judge, the allegations also include dangerous conditions. That has nothing to do with um, the provisions of the agreement or the performance of any parties. And quite frankly, Judge, if you want to get into the weeds of this agreement, it specifically says that, you know, that they aren't providing health care um, to the patients. But I don't want to get lost on that because before we even get to the scope, there must be a valid, the parties must have consented to this agreement. And our position is that this individual who signed this agreement, who is no longer alive, did not have the authority to sign it in the capacity that it is on behalf of Miss Powell.
Okay. Alrighty. Thank you. Thank you. One last, since we don't really have time, but we do have time. Sorry, I have you here. Is that had you all, I didn't hear that you all had come to an agreement on the motion to determine plaintiff's claims are health care liability claims. Is that something that you all are prepared to go forward on today?
Judge, from the defense, I think that it's a little bit related to the what they're ultimately asking is to send it to arbitration. A healthcare claim doesn't send it to arbitration. I didn't respond to that because when they filed it, they had emailed the court and asked it to be on this day, and they said it wasn't going to be on this day. But Judge, we've filed this lawsuit, and it has claims where initially it's been filed as just a regular negligence claim, and we plan on proceeding on that. We've also filed it as a Chapter 74 claim too. So we have both avenues. It would be our position that that would be determined by the jury when we had the trial, because the elements of the offense wouldn't necessarily change. Again, it's our position, it's the defendant trying to backdoor this to an arbitration agreement, that there isn't a valid arbitration agreement in this case. I'll be honest, Judge, I'm not prepared to address that.
That's fine. No, that's fine. But here's what I would like to do. For that April 15th setting, we're going to move you all to 8:30. Okay. And so it's set for a final civil pretrial. The motion to compel production and this motion to determine plaintiff's claims, our healthcare claims, will also be at that time. Okay. I'm not, and I don't mean to indicate anything with respect to the motion to compel arbitration. It's just I have to be prepared so that we make sure and cover everything with the amount of time that we have. And it's not going to work to have you all at 10 o'clock with everybody else. 8:30. Okay.
Judge, will that be on Zoom or in person?
No, on Zoom.
Okay.
Okay. Anything else?
No, Judge, thank
Anything
you so
else
much.
that needs to be heard? Since I'm going to have you all at 8:30 on next week.
I think that's all of the outstanding motions.
Okay, then get out of here before anything else comes up, and we'll see you next week. Appreciate your time.
Thank you, Judge.
Thank you, Your Honor.
Thank you. Have a good day. All right, let's bring in our friendly suit.
Yes, ma'am. Also have a Miguel Lewis, Judge. He's not the pro se or the ones. Can I bring him in too?
Sure.
I'm sorry, Your Honor, for next week on that last case, is it motion for reduction and then the motion to determine plaintiff's claims?
Motion to determine plaintiff's claims and motion to compel production, correct?
Okay.
Miguel Lewis, I think let me see. Let me get back to the case. Oh, he's got to be related to this. Yeah. Okay. Yeah. Who's here? Thank you everyone for your patience. We've had an extremely busy docket with like real meat and bone stuff. And so I apologize for the delay, but you all were scheduled at the same time as another one that needed to be quickly.
That's
so
okay.
Thank you for your patience. And one last thing I need to check, and I'm positive I already have it because I think I saw it, was Angie, your report. I believe I got your report already. Did I?
I forwarded it directly to the court because it does have some confidential information related to the children, so I didn't file it.
I reviewed it. Yes. My brain is full right now, so bear with me. All right. If everyone's ready, let's go ahead and call it. Calling cause number 2025 DCV 3277, Cassandra Lewis, and as next friend of minors versus Diana Jurado Hernandez. May I have announcements, please?
Melissa Crampota for defendant.
Your Honor, the plaintiffs are pro se. So we have Cassandra Lewis and Miguel Lewis, the parents of the minor children here present.
And I do see Mr. and Ms. Lewis appearing. This proceeding is being conducted remotely over Zoom. Angie, you want to go ahead and announce as well?
Yes, Angelica Carrion Beltran. Oh, I'm sorry. Angelica.
No, you're fine.
As the ad litem.
Thank you very much. And we are set for a friendly suit today. I did receive Ms. Carrion Beltran's ad litem report and I've reviewed it. So how are you all wanting to present today? Ms. Carrion, are you going to take the lead, or is Ms. Lewis or Mr. Lewis going to take the lead? Who are we calling?
I can take the lead, Your Honor, if that's okay.
Thank you.
And because Cassandra Lewis, you're designated as the next friend on the pleadings, I'm going to call you as a witness, if that's okay.
Okay, no problem.
Ma'am, would you raise your right hand? Please, do you swear or affirm any testimony you provide will be the truth and the whole truth?
Yes, I do.
Thank you very much, Ms. Carrion. You may proceed.
Thank you. Ms. Lewis, your children were involved in a vehicle accident in El Paso County that resulted in injuries to one of your daughters. Can you identify which daughter was injured?
Yes, it was Chanel.
And Chanel had to go to the hospital. She had, my understanding is, some soft tissue injuries, but she was treated in Pecos and then at the Children's Hospital in Lubbock. Is that correct?
Correct.
And your other daughter, Khaleesi, was also in the vehicle that was involved in the accident, correct?
Yes.
And your insurance, which was TRICARE, covered those medical expenses, and they have asserted a reimbursement claim to which everyone has agreed to do. Is that correct?
Yes, correct.
And how are your children doing now?
They're good. I think they still, they have some moments in the car where they might be a little nervous sometimes on road trips, but I think for the most part, they're doing okay.
Okay. And you have agreed to enter into a settlement agreement with the insurance of Diana Jurado Hernandez. Is that correct?
Yes.
And the policy limits were paid for the 3 passengers in the vehicle. Is that correct?
Yes, correct.
And the limits were divided in a way that both daughters, after paying the TRICARE lien, both daughters would be left with the same funds, and those funds are going to be invested into a structured settlement. Is that correct?
Yes.
By agreeing to the settlement that was offered, you understand that there will not be a trial in this case.
Correct. Yes, I understand.
And by waiving your right to trial, you're also waiving the possibility that a jury or judge could find that the girls are entitled to more money or less money, that it's an option that you knowingly waived. Is that
yes. Yes, correct.
And you do not believe that the girls are in need of any further treatment or medical attention at this time?
I don't think they do.
Okay. And you have agreed to release the insurance company for any and all future potential liability. Is that correct?
Yes.
Do you believe that the settlement terms or the settlement funds that are being distributed are in your daughter's best interest?
Yes.
I pass the witness, Your Honor.
Ms. Crampona, do you have any questions?
Just have one. In addition to agreeing to release the insurance company from any future claims, you're also agreeing to release Diana Hernandez from any future claims. Is that correct?
Yes, correct.
Okay, thank you. That's all I have, Your Honor.
Okay, thank you very much. Ms. Carrion, you have any follow-up? No?
No, Your Honor.
Okay, thank you very much, Ms. Lewis. Will you be calling Mr. Miguel Lewis?
Yes.
Okay.
Sir, you are the girls, Khaleesi and Chanel's father, is that correct?
Bear with me. Let me just swear him in real quick. Sir, would you raise your right hand? Do you swear or affirm any testimony that will be the truth and the whole truth?
Yes, I do.
Thank you very much. Put your hand down. Would you state your name for the record?
Miguel Kenny Lewis.
Go ahead.
Mr. Lewis, you have heard the testimony of Cassandra Lewis. You also live in the home with the girls, Khaleesi and Chanel, is that correct?
Yes, ma'am.
And you have been involved in this litigation, actively involved in negotiating the settlement and the payment to TRICARE, is that correct?
Yes, I have been.
And TRICARE is going to be paid in full, and the girls are each going to receive the same amount that's going to be invested into a structured settlement, is that correct?
Yes, ma'am.
And that amount is $13,885.01 for each child. And based on the investment, they're going to net a little bit different amounts just because of their ages. But do you believe that that structured settlement is in the girls' best interest?
Yes, I do.
And do you also understand that by agreeing to enter into the settlement, that you, on behalf of your daughters, are waiving the right to a trial?
Yes, I understand that.
Where a trial verdict could be more or less than the settlement that has been agreed to currently.
Yes, ma'am, I understand.
And you understand that Ms. Hernandez, as well as her insurance company, would have no further liability for anything that may arise in the future relating to this incident on behalf of both Chanel and Khaleesi.
Yes, ma'am, I understand.
And you believe that this settlement is in your daughter's best interest?
I do.
Thank you. I pass the witness, Your Honor.
Thank you, Ms. Crumpota. Do you have any questions?
No, I don't, Your Honor.
Thank you very much. Thank you both, Mr. and Ms. Lewis. Ms. Carrion, do you have anything else?
Your Honor, only that my ad litem fees were a little bit higher than normal because Mr. Lewis and I both tried for a number of months to get TRICARE to respond. Their lien was somehow lost in a system when the system divided recently or within the last year. And so I'm asking for $1,720 in ad litem fees, which has been agreed to by defense counsel.
Okay. You said 17, how much?
1720.
1720. In the report, in the report you provided, Ms. Carrion, it's a different amount. Am I missing something?
Honor, on page 3 of my report, I don't know. It does say the 1720 on the last paragraph 10.
So the copy I have says 2,500. Let me make sure I'm looking at the right one. Yes.
And I think I sent an amended report, forgive me, once I did all the calculations.
Okay, let me see.
1720, Your Honor.
Let me make sure I'm looking at the right one.
I do see 2 reports in my file. I must have filed one or submitted one earlier and then submitted a second one once we were able to determine the structured settlement. And
okay, if you would resend that one, I do not have I don't see the one that has the changed, the amended fee, but those are approved. Those are approved along with the remainder of the settlement as being in the best interest of both your daughters. I hope everything is going well and you all are able to move on. Thank you for your time today. If I heard also along with that, Ms. Bertrand, get the conforming documentation so we can get everything set up with the district clerk's office and I will sign off on everything, okay?
And so the order or the judgment has been forwarded to you, Your Honor, which references and I believe I saw that it was e-filed, but that went through this morning.
Okay.
And because it's a structured settlement, we don't have to go through the district clerk.
Got it. I don't have any documents, so maybe we can check with, it might be just easier if you would resend
the last one to sign, so I will make sure that we get those to your coordinator.
Thank you very much. Thank you, Marissa. If you see them, send them to me, but at least when I'm searching by the cause number, maybe it's not listed with
Yes, Your Honor, I only have the first ad litem report from March 25th.
Yeah, that's what I have too. Okay, sounds good. Thank you very much. We'll follow up with you. And if there is nothing further, then we are adjourned.
Thank you, Your Honor.
Thank you.
you for your
Thank
time.
you.
Y'all are excused. Have a good day. Good luck to you.
You too.
Bye. Is that the last one, Mr. Nunez?
Yes, ma'am, that's everything.
Mira, it's 11:35. Hi, Miss Uran.
Hi, Judge. Good morning.
How are you?
Oh, I'm good. How are you?
So civil's been a little nuts lately.
Yes, very. And I just wanted to ask and clarify, notices of non-suits, you want us to close out the
So
cases now?
can we get off of YouTube, please?